1.
None appears. This was not. Oh, you're there.
I'm there for the petitioner, my lord. But in this case, the petitioner is no more. He's already passed away.
The petition is stated to have expired. The petition is disposed of as having abated. All right, sir. All right. Thank you.
Special weekly list item number 2.
None appears. This was normal.
Special weekly list item number 3.
It may please yours.
Yeah.
The petitioner has challenged the order of the Learning Tribunal,
Yes.
Orissa Tribunal, under Annexure 1,
10th May 2004.
under Annexure 1, my lord.
Period of absence of duty. Want to be
That,
treated as working.
That on the purpose ground, this has been dismissed, the OA has been dismissed. I prayed for my lord for a direction, if I filed the OA for a direction to the opposite parties to allow me to join in service, my lord. While the petitioner was appointed in the year 1989, that is 21/8/1989, as a constable in excise department, and his service was terminated without following the procedure of CCA rule on 29/4/1993 without giving any opportunity of being heard, my lord. I preferred an appeal before the collector Koraput, and collector allowed the appeal directed to reinstate me in service with all the benefits, my lord. That is on 24/9/1993, my lord.
The only problem is the acquittal was benefit of doubt. Acquittal.
That is acquittal, my lord. I am coming, my lord. Acquittal, the benefit of doubt, they say only that date of birth of the petitioner in the certificate has been manipulated. That is the allegation, my lord. They say that in place of 1965, I have put it on 1963. That is the death of my elder brother, my lord. That is to be proved, my lord, in a disciplinary proceeding, my lord. Whether that has been manipulated or not, without initiating disciplinary under CCA rule, they
Oh, I
cannot.
see. They did not initiate any disciplinary procedure.
No, my lord. Even not a single show cause has been given to me, my lord.
Oh,
Lord,
Therefore, I have cited a decision of the Honorable Supreme Court, my lord. I have given a copy, my lord, that
right.
2007, year SCW 2023,
Ah.
there same thing happened, my lord, that they said the fourth certificate was given. There, the Honorable Supreme Court held that without initiating a disciplinary procedure, you cannot terminate his service.
Correct.
My lord, they reinstated me in service. My
Right.
lord, I was yelling. Therefore, I sought time to join. Thereafter, my lord, after when I went to join, my lord, they lost the affair thereafter. And lost the affair, they said that as criminal proceeding has been initiated against you, you can't join, my lord. Then I filed the way before the Learning Tribunal that I may be allowed to join, my lord. Now, the Learning Tribunal said that collector is not appellate authority. In the counter, they have admitted that the collector is the appellate authority, my lord. They have not challenged the order of collector in any appropriate forum, my lord. That remains, my lord, binding on the government. Your losses kindly, para 9, page 14 of your losses kindly see.
In your list of dates, there's no collector's order, nothing.
Collector's order I have given, my lord, Annexure 29/4/1993, list of dates, Annexure 4.
Oh,
My lord, the collectors that what they have, the Learning Tribunal has come to conclusion at paragraph 9. As I have stated above, an order of the institute passed by the collector cannot be given much importance as he was not the appellate authority, my lord. Your losses kindly see in the counter file before this honorable court, the government has said the collector is the appellate authority.
Oh, I
That is
see.
completely perverse, my lord. Paragraph 4.
That in reply to the government's.
My lord, I am coming to the counter reply, paragraph 4. Subsequently, after dismissal from service, the petitioner filed an appeal before the appellate authority. That opposite to praying for his reinstatement. The appellate authority on due consideration passed the orders of reinstatement of the petition in service. They admit that he is the appellate authority. At that time, there is no rule. Rule came into force in the 2011, my lord. At that time, there no on the instruction, government instruction, only that appeal is before the collector.
Well, Lord, may I just, Lord, admittedly, no disciplinary proceeding was initiated against the petitioner. But when the date of birth was found to be false, my lord,
Found by whom, sir? This is the whole problem. Without an inquiry, how do you find?
because that was challenged by the petitioner before the collector, my lord.
And he succeeded.
He succeeded.
Ha.
Then he was asked to join the service, my lord.
Ha.
Now, your lords may kindly see the following lines, my lord.
Ha.
He was asked to join the service. He did not join. He asked for time. It was granted till November 1993. The collector passed the order on 24th of 993. Your lordship may first see the last two lines of the counter affidavit. First page, last two lines. The appellate authority, on due consideration, passed orders for reinstatement of the petitioner in service, subject to trial of proceeding as per CCA rule, and treated the period of dismissal as duty by order dated 24/9/93. Copy of which filed with annex of B/3. But the petitioner, instead of joining in service, sought for time for his joining till end of November 1993.
No. So what the charge against him is that he was late in joining, and so you're dismissing him.
No, he did not join.
No.
All right. So assuming he did not join, what do you do?
Well,
Assuming that delay in joining.
Yes.
Is that the charge why you're keeping him out, or you're keeping him out because of the criminal case?
Because at that point in time, criminal case was not issued.
Either way, sir. If there's a delay in joining, you should issue show cause notice. If it is for education certificate, which you say is forged, you have to issue show cause notice.
My lord,
Either way, sir, whatever be the reason, can you do it without an inquiry is the question.
so far as, my lord, the for certificate is concerned.
No. You have to be clear. Why are you keeping him out? Why are you terminating his service? Is it because he refused to join? Can't be.
No.
Because you have anyway set aside that order, you asked him to join.
But since he did not join, my lord, 3 months.
So you should then give a show cause notice saying we gave you time to join. You have not joined, and therefore show cause why we should not remove you from service. Have you done that?
No.
Then
We have explained that since after that the affair was lost.
So that is not the reason. So what you're now putting forth is not the reason why you terminated the service.
Not.
The challenge in the present petition is to an order dated 10th May 2004, passed by the Orissa Administrative Tribunal, Cuttack bracket OAT, dismissing the petitioner's OA number 2260 bracket C of 1999. The background facts are that after qualifying in a selection, the petitioner was appointed as an excise constable by an order dated 1st August 1989, at Koraput. Full stop. The petitioner joined duty in the month of August 89. While he was working as such, he received an order dated 29th April 1993 stating that he was being dismissed from service with effect from 30th April 1993 afternoon, open quotation, due to furnishing forged educational certificate, full stop, unquote. Admittedly, there was no show cause notice issued to the petitioner prior to this order. Aggrieved by the order of termination, the petitioner filed an appeal before the collector of Central Excise. So it must be mentioned at this stage that although the OAT has in the impugned order formed an opinion that the collector was not the single court's appellate authority, and court, and therefore the order passed by the collector would not make a difference, in the counter affidavit filed by the opposite parties, it is clearly admitted that the collector was in fact the appellate authority. Full stop. As it transpires, by an order dated 24th September 1993, the collector of excise, Koraput, passed an order reinstating the petitioner in service with immediate effect. Full stop. paragraph, it is stated in the counter affidavit that although he had been asked to join within 3 days, the petitioner sought time for joining and submitted an application on 7th October 1993, praying time till end of November 1993 for joining. Full stop. It is stated that this prayer was not acceded to. Stop. On 18th October 1993, he was asked by the Excise Department to join immediately. Full stop. Apparently, the petitioner submitted another application on 26th October 1993 for reconsideration of his application. Paragraph. While the matters were pending thus, under the orders of again the collector only, is it? The FIR was lodged in the orders of the collector.
No. The FIR was lodged by the Excise Department, superintendent by Excise.
So on the orders of the superintendent excise, the first information report bracket FIR bracket was lodged against the petitioner for the offences under section 420/467 IPC in the town police station Koraput on 9th November 1993, which was registered as PS case number 190 of 1993. Full stop. It is claimed by the department that, notwithstanding the above FIR, the petitioner was given time up to 5th December 1993 for joining, but the petitioner kept seeking more time to join. Full stop. So right now there's no termination order, sir.
No termination order.
You're just seeking permission to join.
No, I joined. I submitted my joining report. They did not allow me to join on the ground that criminal proceeding.
When did you submit the joining report?
Well, that in a way I have mentioned that original application, my lord.
Because all that comes through, you kept asking time.
Yes, no, my lord. It's just I on 5/12 in December I joined, my lord. They did not allow me. December 1993. Only 1 minute. I mean, region to abstain. My lord, first I joined, then after acquittal I joined, submitted my joining.
No. After acquittal is not the point, sir. Before
22/9/1998. Done in December 1993, I joined, my lord.
Where do you get that?
That, my lord, I didn't pay the counter the extension letter joining on 15/11/93. Could not serve, so it is the manifest clear that I'm giving that date, my lord.
No, you sought further leaves. Para 5 of the counter. Just come to para 5 of the counter.
And in reply passage, it is that respectively some of the petition submitted an application 12/11/93 for the free further leave on medical ground without any supporting medical evidence, and she was rightly directed to join in duty by letter number 3618, dated 1/12/1990. That was not communicated to my lord. But the petitioner intentionally did not receive the said letter as per report of serving officer, nor joined in duty thereafter. It is expected some sufficient opportunity given to be neither joined in service nor turn up to carry out the order of the opponent to. The petition submitted.
Did you actually join, sir? This doesn't seem to be that you actually joined.
After I joined, my lord, as my joining report was not accepted, I filed the original.
You are saying all this orally, sir. You're not showing us a single document. You're not showing a single avowment.
That is an engaged
And
brief.
the OA
Therefore,
was filed in the year 1999, my lord.
OA is filed in 99.
99. And in the rejoinder, the petitioner, in response to paragraph 4.
Where is the avowment that you went to join and you did refuse
yes,
to
my
let
lord,
you
I am
join?
giving.
There's no such avowment also.
As it is my engaged brief, therefore I am facing it difficulty.
See that representation.
But only one date is available after acquittal. I submitted my joining at 12/8/1999.
That is much later, sir.
I know, my lord. I know because the original application is not with me. Therefore, I am not unable to give the date, my lord. Because it is an engaged brief. Only 20. I have with me the date 22/9/1998. My lord, only date is available. Other date is not available with me, my lord, after acquittal. But I have been informed in the December he joined, my lord. Want to join, but
There is no avowment, sir. Neither avowment in the OA also. There's no such avowment.
OA, my lord, OA file is not with me. Therefore, I am unable to file that. I can't give the date at present, my lord.
Is there a file? OA file.
My lord, OA file might have been. Your lordship, my lord, keep it next week. I will give the exact date of joining.
No, even in a writ petition, sir, there is no such
I will
avowment.
give by open affidavit the exact date of joining in the month of December 1993.
No, you gave a representation saying, give me time till January 2004.
Yes.
I mean, 1994.
98, man.
94.
No. 90. You gave a representation on 5th December. Now come to the counter affidavit.
Yes, man.
You are not joining back, sir. Paragraph.
Five, my lord, that
Paragraph 5.
paragraph 5.
You submitted an application on 12th November.
22 September 1999. I have submitted the application, my lord, 12th November.
No, continuously submitting application saying because of
You were
medical
jailing, my
grounds.
lord. You were unable to move. Therefore, this made the application, my lord. You were jailing, actually. He has stated, my lord, he was jailing, my lord.
That's right.
In the representation that is given
You
on
didn't join back, sir.
22/9/1990.
So the fact of the matter is you did not join back.
Well, that date is not with me, my lord. Sorry, my lord, I have not. That annexure 5 only I have given. In the counter they have given me.
Very strange, sir. You were asked to. There's only an order of reinstatement. There's no order of removal. You have not joined back.
My lord, 1/12/1993 joining. Further, he is given to extending the date of joining till 5/12.
It's strange.
Should join and duty
Look at the
before
strange thing,
undersigned
sir.
5/12.
I don't think at any time they stopped you from joining, despite the FIR. There was no order placing you under suspension. There was no order terminating your service.
Nothing, my lord.
Then there's nothing to set aside.
Only that,
Despite the criminal case, they did not
only
suspend
that
you.
the order of the Lord Tribunal, my lord, that is to be set aside, my lord.
You're missing the point. There was no order terminating your services.
Yes, my lord.
Nothing prevented you from joining back.
You'll also keep it next week at satisfactory. You'll also keep it next week.
Oh, they got all that. Mrs. Say.
Next week, my lord, they need it. I will give you details, my lord.
At the request of Mr. Monty, Mr. 9th. All right.
Special weekly list item number 4.
Lack of pleading, I would know.
Item number 4.
None appears dismissed from prosecution.
Special weekly list item number 5.
None appears dismissed from prosecution.
I am for the opposite party.
All right, sir.
Special weekly list item number 6.
May I please, your lordship?
Yes.
Item number 6, your lordship, annex or challenge. The retailership has been
Sir, you are not audible, sir.
but I have challenged that annexure 9 page 67.
You'll have to speak into the mic. I think you're turning your face away and looking at something and speaking. It's not audible.
I am sorry. I am sorry. But the annexure 9 is impugned before lordship, page 67. It is the license has been given for 5 years. I think what instruction the state government has, I
All
don't
right.
know.
Concept of the petitioner states that the petitioners have been rendered infructuous due to passage of time. It's disposed of as such.
Special
But
weekly
if
list item.
may say no instruction, if there will be any cause of action, then I can.
No, sir. Not a 2008 matter. Right.
Item number 7.
Not pressed, your lordship.
Not pressed, disposed of. Not pressed.
Special weekly list item number 8.
My lord, I am on behalf of R.N. Mishra. Now he is in government panel and the matter is to be transferred. Right?
Sorry, matter is to be?
Transferred.
No, not like this, sir. It's a 2008 matter.
My lord,
Who are you in the first matter?
No, my lord. In the first matter, I am for the petitioner. Here, the labor court award has been challenged by both the parties. Now, the petitioner, the employee was a DLR, was engaged on DLR basis by the Orissa Water Supply Storage Board for a particular scheme. My lord. Now, the scheme, when the scheme was coming to an end, there was some allegation made against the DLR, and the petitioner's service was not extended by the board then. Then, challenging that non-extension of service, the petitioner approached the Learned Labor Court. My lord. And the labor court's award in the labor and the Learned Labor Court, my lord, in the impugned award had stated that had mainly stated 2 points, my lord, that on one that the inquiry which was conducted by the petitioner, he was never given an opportunity of hearing, and secondly, he has stated the main point that was taken by the board, that it is not an industry as per the Industrial Disputes Act.
That was taken negative.
That is negative.
Yeah.
But however, since the project was already closed and it was a scheme-based project, so the project was closed. So therefore, the labor court directed to pay 50,000 compensation as a one-time measure to the board. Now that order has been challenged by both the parties.
All right. We dismiss both petitions. You say both these petitions, one by the management and other by the workmen, are directed against the same impugned award dated
my lord,
6 September 2007. passed by the Labour Code Jaipur Korapat in Industrial Dispute Case number 3 of 2006. Paragraph. The dispute referred to the Labour Code for adjudication was as under. Take from page 37 in that schedule area under the schedule paragraph. The case of the workman was that he was a regular workman whose services were terminated on false charges of misconduct without compliance with the principles of natural justice. The case of the management, on the other hand, was that the services of the workman were engaged as a daily wage laborer. Is it DLR?
Daily labor returns, not DLR.
Daily
labor returns. Daily wage labor.
As a daily wage laborer. And it was single quotes scheme based, unquote. With the scheme having come to an end, the services of the workmen were dispensed with. Paragraph. 2 questions that arose before the Labour Court was whether the Orissa State Water Supply and Sewerage Board (OWSSB) that is the management was in fact an industry within the meaning of the Industrial Disputes Act 1947 (ID Act). This was answered against the management. Paragraph. As regards the validity of the termination of the workman's services, it was held that since it was not preceded by a fair inquiry, the termination of services was bad. However, the only relief granted was payment of lump sum compensation of rupees 50,000 to the workman. Paragraph. On the part of the workman, it was not able to be established that he was being regularly employed. And therefore, on that part of the impugn award, not reinstating him in service, no fault can be found. As regards the violation of the principles of natural justice, again, the management cannot have any grievance since in fact no inquiry was held before the termination of services. As regards OWSSB being held to be an industry within the meaning of the ID Act, again, there is no error committed by the Labour Court in this regard. Paragraph. Having heard learned counsel of the parties and having examined carefully the impugned award of the Labour Court, the court finds no reason to interfere. Both petitions are accordingly dismissed. The interim order stands vacated.
Special Legal List item number 9.
Item number 9 on behalf of Mr. J. M. Patnaik. Lordship, this matter may be taken up next week.
No.
Because file is not traceable.
All right. Counsel, the petitioner states that the file is not
Lordship,
traceable.
may be passed over.
The petition is dismissed.
Pass
With
over,
liberty
Lordship.
to the petitioner to revive the petition as and when the file is able to be
Your
traced.
Lordship, pass over this matter.
It doesn't matter, sir. If you don't have a file, pass over will not improve it. Yes.
I will collect.
Special Legal List item number 10.
I am appealing the opposite party. Mr. Chivanka.
All right, sir. All right.
No. I am appearing in this case.
Always.
Item 9.
Yes,
Item 9 has been called up.
9 I am appearing.
Sir, 9, Mr. Satpathy is appearing, sir. Zarina Marines.
Yes, it is Balesar case.
He is appearing in every case.
Yes, who's for the petitioner?
Yes, ma'am.
Oh, that's what. Oh, that's over then. Right.
Item number 10.
The memo is taken on record. Dismiss is not pressed.
Special Legal List item number 11.
My lord, no instruction.
No instructions dismissed.
Item number 12.
None appears dismissed. No prosecution.
Special Legal List item number 13.
States, Mr. Mishra or Mr. Padi. None appears dismissed.
Item number 13.
All right. None appears dismissed. No prosecution.
Special Legal List item number 14.
May it please your lordships. Here, my lords, the case is that nobody should be judged in his own case. The principles of natural justice, this is the case here. Lordship will kindly see Annexure 2.
What's the tax effect, sir?
Tax effect is 1,22,000, my lords.
All right.
My
Okay.
lords, I'll just point out
Yes.
Annexure 2 at page 15, sir.
No, who's for the other side?
Their cell tax department, my lords.
No, I know. Who's up here?
Your Lordship, let it be pass over, Mr. Padhi. This case has been handed over to Mr. Padhi. Let it be
All
pass
right.
over. Your
Pass
Lordship.
over. All right.
Special request item number 15.
Mr. Mishraf, are you there? 15.
Your Lordship, today, Mr. Padhi, I'm in another court, Mr. Padhi. Your Lordship, let all these, these 3 to 4.
Your Lordship, on behalf of Mr. Siddhant Simar Padhi, I'm pass over, Your Lordship. Yes.
All right. Pass over.
Item 16.
Item 16, the tax effect is very low.
All right. Tax effect being low, the petition not rest and is disposed of as such.
Okay.
Item number 17.
Same pass over.
Yes, Your Lordship. Yes,
All right. Pass over.
Item number 18. Special request item number 18.
None appears dismissed. No.
Special request item number 19.
Pass over.
Special request item number 20.
None appears dismissed. No.
Special request item number 21.
None appears dismissed. No.
Special request item number 22.
I'm in hybrid mode, virtual mode, my lords. It has become infructuous by efflux of time.
All right. By efflux of time, the petition has been rendered fructuous. Disposed of as such.
Special request item number 23.
Dismissed for non-pass. All right. Dismissed for non-pass question.
Special request item number 24.
My lord, not complying the order dated 21/1/2010, passed in WPC number 107 of 2003, my lord.
What was the order? What is the complaint?
My lord, they have also filed their counter.
What is the matter about, sir? Tell us. What was the order passed by the court? Consider representation.
My lord, my lord, my lord.
Compassionate ground. See, if he has, this, look at the nature of the relief, page 9.
Page 9, my lord.
Para 5, read it.
It is therefore directed that the case of the opposite part number 2 shall be reconsidered by the petitioner for compensatory ground, and the same should be done in the light of observation made by the tribunal in the impugned order. Any order passed by the competent authority in this regard should be rescinded order meeting in the observation made by the tribunal in the impugned order, so that the same can be subject to scrutiny of the court. While deciding the issue, the contempt authority may look into the relevant rules as well as the circumstance discrimination alleged by the opposite part number 2 in the original application and pass order in accordance with law.
So they
The
should
order
have
of-
passed that order, sir. You have not challenged it.
My lord,
They have passed that order. You say the order dated 6th October 2010, issued by the opposite parties.
my lord, let me give me a chance. May I examine that?
No. That you examine in leisure, sir. It appears that pursuant to the order passed by this court, in writ petition civil number, order dated 21st January 2010, passed by this court in writ petition civil 107 of 2003, the opposite parties have passed an order dated 1st/6th October 2010. So if agreed with the said order, the correct course for the petitioner to adopt was to file a fresh writ petition and not the present contempt petition. Full stop. Consequently, the court is not inclined to interfere in the present petition and is dismissed as such.
Special legal list item number 25.
25 to 28. The certified copy of the impugned order.
All right. No certified copy of the impugned order has been filed despite 11 years having elapsed. The appeals are dismissed.
25, 26, 27, and 28.
Special legal list item number 29.
29 no instruction.
No instructions disposed of.
Special legal list item number 30.
None appears to not.
Special legal list item number 31.
Minutes for 31, we have no instructions. Minutes.
No instructions disposed of as such. Yeah.
Special legal list item number 32.
It's a read of it of filing of MBBS examination of 2011 matter. Now the time is elapsed matter.
Sorry?
The time is elapsed matter. 2011 matter.
All right. Due to passage of time, the petition has been appeal has been rendered infructuous and is disposed of as such.
Be privilege.
Special legal item number 33.
The impugned order, the
limitation
98 years old respondent now.
And at the time of filing of the appeal itself, the opposite party was 98 years old.
No, 88. Now it is 90.
All right, 88 years old. Consequently, the court is not inclined to interfere in the matter.
Fighters' pension that was challenged,
And the matter concerned the grant of pension. Consequently, the court is not inclined to interfere. The appeal is dismissed. All right.
Special legal list item 34.
34 delay of 738 days.
738 days delay is not properly explained. Accordingly, the application for condemnation of delay is dismissed. Consequently, the appeal is dismissed.
Special legal list item 35.
None appears dismissed in opposition.
Special legal list item number 36.
36, 1488 days delay.
All right, 1488 days. Same order, dismissed or delay.
Item 37.
Let the impugned order is at Annexure 7. That the member board of revenue, by exercising the power under section 38B of the OE Act, has.
Sir, all these cases you can withdraw and go to the civil court. That's only relief.
Usual orders, your lordship is passed.
No, this is not the, because the consultation authority, by exercising the power of the civil court, has already declared the title of the petitioner. So therefore, there is no, in view of section 51(1) of the Consultation Act, there is a specific bar to go to the civil court.
No, now,
Again.
sir, that all is over. Those proceedings are over. This is under the OE Act.
The proceeding, your lordship kindly allow me for a moment. Let here is a case, let a Stitivan right of the petitioners were directed to be recorded in the name of the government under the Anavadi Khata. Before that, my lord, before 24 years before this order was passed, my lord, this procedure, the consultation authority and the consultation operation came in operation to the area, and Consultation Act, your lordship kindly see for a moment. Section 4(4) read with section 51(2) of the Consultation Act. It specifically provides that the civil court power, the power vested under the consultation authority to examine the question of title in respect of a property, and the civil court power is ousted during that period. So therefore, by exercising the power of the civil court, the consultation authority in Annexure 4, your lordship kindly see. Consultation authority, by exercising the power of the civil court, has declared our title over the land in dispute by holding that they are the Stitivan tenant. By ignoring such decision, my lord, again, a 38B application was made with the reference of the collector, and the member board of revenue entertained that petition, and without examining the legal consequence of the order of the consultation authority, has passed the order that should be recorded under the Anavadi Khata. So member board of revenue has no jurisdiction to touch the order of the consultation authority. By exercising the power under section 38B. But I am raising three legal questions before your lordship. that, and I am assailing that order, that there is no dispute about the fact that it is the Sthitivan property of the petitioners, of the vendor of the petitioner. And the consultant, the member board of revenue in the impugned order has hold that right has been vested to the state. That is by holding that he has changed the basic structure of the estate abolition law. The tenant's right will not vest in the state. Only the intermediary state, whatever name it may be called, that will vest to the state without touching to the tenant's right. So the petitioners being the Sthitivan tenant, their right cannot be vested with the state. And since there is no order under the State Abolition Act, so 38B has no application. That order is without jurisdiction. My second submission before your lordship, that once the consultation authority, by exercising the power of the civil court, has decided the question of title in favor of the petitioner, the member board of revenue has no further jurisdiction to touch that order under section 38B. And the order which has been quashed below, the recognition of their tenancy in the 1985 and passing the order by the OA collector to accept the rent below, that is not an order under the act below. If it is not an order under the act, so therefore the member board of revenue has no jurisdiction to touch that order. That is the three preliminary questions I am raising before your lordship for my lord's consideration. I have prepared an exhaustive note because he has, by passing the impugned order, the member board of revenue has changed the basic structure of the state abolition law.
Just give him the copy.
Yes, Lord, I will give.
Take it at the end of the board, sir.
My lord, may kindly have a glance over my counter affidavit.
Yes, yes.
What point he
Take
has
it at the end of the board. We have to hear him first.
And see this.
Take it at the end of the board. All right.
It might be taken up.
Yes, yes. End of the board.
Yes.
That's so may I make a mention, but item number 35. As I was bit late to lawsuit, lawsuit can dispose of on made because it's a writ appeal against the order passed by the honorable single judge regarding revaluation of answer script of the student. Lawsuit made to pass an order.
Yeah, it is the present appeal 35. Is a present appeal is directed against an order of the learned single judge ordering re-evaluation of the answer script of a student. Clearly, by passage of time, the appeal has been rendered infructuous and is disposed of as such.
Oblate.
Item 38. Can it be taken up after recess?
No. Tell us what the matter is.
Yes, I am placing. Here, in fact, a revisional order, confirming revisional order passed under the OEA Act is under challenge. The claim case is under Annexure 7. Then appeal was preferred under Annexure 8. Then revision was preferred. That has been.
Is it covered by the judgment of the Supreme Court?
No, that is not applicable. I will demonstrate it. I will demonstrate it. Lords, may kindly have a glance at the present petitioner status. I am just placing Annexure 1. Let's may kindly have a glance. Because that judgment, Siddhamata judgment, I am preparing the copies. That is why I am praying that I am getting those copies. I have to supply it for your lordship. That's why I am getting.
You may have Siddhamata. You have the judgment, no, sir? Mr. Mohanty?
Yes, my lord.
Siddhamata judgment you must be having?
Yes,
that I am getting because I am preparing the copy.
Yes,
that is why.
With my learned friend.
Copy of the judgment is with me. Your lords may keep it.
Your lords, for convenient.
You want to take it up at 2 o'clock?
Pardon?
You want to take it up at 2 o'clock?
2 o'clock. 2 o'clock. Yes, that is exactly I am praying.
All right, 2 o'clock.
Because I have to place that judgment apart.
Sure. 2 o'clock. None appears dismissed now. None appears dismissed now. Prosecution. None appears. Justice Nova. None appears. The whole lot.
42, item 42, there are many cases.
Disappearing, sir. None appears. Justice Nova.
Sir, item number 43 is a single bench assignment.
All right. Ms. Mahapatra points out that this is assignment of the single judge. Let's move for the roster bench on 16th May. All right.
Fresh reference OP1.
You are for OP1?
No, I am for the petitioner. Fresh reference made to the OP1.
2011 matters, sir. Where's question of fresh representation now?
Some amounts have been pending before the authority. That's
what is pending?
Amount. So, amount.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to follow up with the opposite party authorities in accordance with law regarding his grievance. This is withdrawn with liberty is paid.
Obliged.
Whatever we are for opposite parties. I am appearing for OP number 2. I think the cause of action no more survives. This is regarding that the PIL has been filed and saying that the transformers, poles, all these things are for the distribution line. That is not being properly maintained.
None appears for the petitioner. Counsel for the opposite party.
2. I am for 3 to 5.
2 as well as 3 to 5 state that due to passage of time, the cause of action does not survive. The petition is disposed of as such.
Malad, item 42, I was there inside the court. I couldn't hear, Malad.
It's all right. So, what is it? What is 42?
That 42 is Malad. Malad, in a lease case of the year 1973, Malad.
This has to go back.
Yes, because he claims to be a purchaser after the.
All right. In all these matters, the petitioners claim to be subsequent purchasers.
Yes, subsequent purchasers.
Subsequent purchasers from
who ought to have been noticed by the
from the original lessee, whose lease was terminated by the impugned orders of the ADM. Bhuvaneshwar.
Yes, ma'am.
ADM Bhuvaneshwar in lease revision cases. Full stop. Since notice ought to have been issued to the present petitioners, the input orders are hereby set aside and the matters are remanded to the file of the ADM for being proceeded in accordance with law. Each of the petitioners will appear before the ADM Bhuvaneshwar with a downloaded copy of this order.
Not received.
On 20th, on 1st June 2022, the ADM will endeavor to dispose of all these revision petitions within a period of 6 months thereafter. Till then, the status quo order passed with this court. Is the status quo passed with the court?
No, I think there is no status quo order. My order doesn't reveal.
All right. No, status quo is there. Status quo order passed with this court will continue till the disposal of the revision petitions.
Let's fix up a date, Malad.
1st June, sir. You appear on 1st June before the ADM.
1st June, I'm
petitions are disposed of. Right. None appears. This is not a solution.
My lordship. This matter, my lordship, regarding the extraction of water from river Baitarani, my lordship, and in the meanwhile, the company OP number 14.
Infractuous, sir.
My lordship, I may kindly be allowed to substitute the company. It has been sold out to Arson Mittal. May I be permitted to do so, my lordship?
What? Permitted to do what?
He wants to substitute the successor of that. It is at liberty to file a fresh petition.
Yeah. Due to passage of time, the petition has been rendered infractuous. If there's any fresh cause of action, it will be open to the petitioner to institute appropriate proceedings.
My Lordship, in fact, in this matter, counter and rejoinder have been filed by the petitioners and the state also, my Lordship. I may kindly be allowed to implicate the company who has purchased this thing, my Lord.
No, you
is
file
my
a
claim.
fresh petition.
Let's I am
File a
appearing
fresh
for the opinion number 19.
All right, you file a fresh petition, sir. All right. None appears dismissed no discussion. Miss case, yeah, miss case. All right.
49, this miscase has been filed for recall of order. You Lordship may recall the matter and dispose of the matter due to non-filing of certified copy.
All right. The impugned order is recalled. The writ appeal is
On the ground
restored
of
to file.
delay, the certified copy has been filed. Inordinate delay.
There's an inordinate delay in the main writ appeal. You say inordinate delay in filing the writ appeal. Accordingly, the appeal is dismissed on the ground of delay.
That already been infructuous, I think.
MC number, we say petitions, this application rendered infructuous and is disposed of as such.
48.
Pass. 14.
I beg pardon, I couldn't remain present in the first call, my lord. I mean,
yes.
My lord has dismissed item 14 for
Item 14, I am for the petitioner, my lords.
prior to my
No,
lord.
no, 1 minute. 13. There is a 13, sir.
13.
In my lord, there is limitation. My lord has passed order dismissing it for non-appearance of the petitioner.
All right, we'll dismiss it on limitation. And 13, you say there's an inordinate delay in filing this revision petition. Accordingly, MC number 84 of 98 is dismissed. Consequently, the revision petition is dismissed. 14, sir.
May it please your Lordship.
Yes, Mr. Mishra.
No, Milord, I have item number 48. Lordship said that non-appearance. Non-appearance, Lordship said. Let it come any other day. Let not be non-appearance.
No, all right. We'll just say it's infructuous.
No, not infructuous.
I
will place the matter, Milord, if your Lordship will permit me just now.
All right. Tell us. 48.
Yes, sir.
Tell us.
This is a matter relating to a termination of a teacher, lecturer, approach the tribunal, approach the director allowed to request the order of termination, then management approached this honorable court, lost the case and this honorable court directed to reinstate him in service. Then, my lord, they did not. Then I filed a contempt. While the contempt was pending, a review application was filed. Review was also dismissed on merit after a due discussion, my lord. Thereafter, what they did, they give me appointment and immediately 7 days they terminated my service.
Okay. So you filed a fresh petition only, sir.
Beg your pardon, my lord.
That is a fresh cause of action.
That's why I have already filed a writ application. But here is a case where Lordship categorically directed to reinstate in service.
I know, but you say in the miss case, you say since the petitioner has already filed a fresh petition questioning the order of termination after reinstatement pursuant to the impugned order of this court, it will be open to the petition applicant to pursue that petition in accordance with law.
Oh, nice.
All right. The miss case is disposed of.
With your Lordship's permission, item 41 has been dismissed for default. If your Lordship will take it up.
Tell us, what is it about?
My lord, that is relating to, it is a PIL for dengue and other things. So far as dengue, for prevention of dengue.
Madam, you file a fresh petition. All right. Due to passage of time, facts
My lord,
change.
that part is over. But so far as the management of stagnant industrial water is concerned, that part is still there.
You file a fresh petition, madam. And you can
Lordship
go
may allow me to file a
All right. Counsel, the petitioner seeks leave to withdraw the petition, to file a fresh petition to account for the developments during the pendency of the present petition.
Oblige.
Disposed of is withdrawn with liberty as paid. Yes, Mr. Rai.
Next, 2 at page 15 is the assessment order for the assessment for the period 84-85.
Right.
He raised a demand of rupees 1,22,000, some odd, my lords.
Right.
Then I preferred an appeal. Annex 3 at page 18, I lost it. Then I preferred a second appeal before the tribunal and moved an application for stay before the Revisional Additional Commission of Sales Tax. Under Annexure 5 at page 31, my lords, the additional commissioner, he granted me stay. Then, my lords, you will kindly see Annexure 36, page 35. The same additional commissioner who passed the order of stay, he became the member and author of that order of the tribunal.
Okay.
B.D. Patnaik, accountant member 1, he has authored this order.
Okay.
Dismissing my...
But there is no stay granted in this court, sir. No, all this is over, no? In this revision petition, there was no stay.
No stay, my lord.
Also, the main matter must be over.
No, main matter is over, my lord. Main matter, I am not on stay, my lord. I am challenging the order of the tribunal, my lord.
But that's
because also... my first prayer, lords will kindly see, my first prayer is that the order of the tribunal is vitiated because of the participation of the person.
All right. Now it will go back to the tribunal then.
Yes, my lord. And
yes,
I
Mr. Padi.
Lords will kindly.
They didn't enforce this demand and recover any tax.
Must have recovered.
Then
must have recovered.
We leave the question of law open, sir.
My lords, the question of law is, lords will kindly see the judgment of the Supreme Court.
No, it's obvious. It's a natural justice point.
Yes, that's a natural justice. I have paid some amount. No doubt. I have paid some amount. And so far as the balance amount, I have no information, frankly speaking.
Then we'll leave the question open, sir.
But I have great expectation so far as my lord is concerned, that your lordship will appreciate the doctrine of...
what will happen is we will remand it now to the tribunal.
Yes.
After so many years.
Yes. That will be, my lords, because lordship will just... only exception is doctrine of necessity.
You might invite a fresh order of raising a demand against yourself by the new tribunal.
No,
then you will again be chasing. You will again then come back.
No. That
is a risk you run.
My lords,
if you're confident on merits, then all this is useful. If you're not,
I am confident on merit. Okay. I wanted to shortcut your lordship's time. That is why I have the Justice Bhagwati and
man cannot sit in the
Justice Bhagwati and Justice Madden's judgment. And it went from the Orissa High Court.
All right.
J. Mahapatra and Company, 84 Supreme Court.
Correct.
Page 1573.
Correct. Well settled, sir. Yes, Mr. Padi.
Yes, madam. As regards the first...
now,
that's the only ground.
Yes.
My lord would find from record that pending the appeal before the Honorable Tribunal, he has moved a stay application before the Additional Commissioner.
Yes, that I have stated. I have brought to the notice of this Honorable Court, that is Annexure 5.
Yes, anyway.
I have not...
My lord would find that stay application was decided by a person who happens now to be the accounting member before the tribunal. My lord.
Right.
Not in any appeal or in any statutory officer he has decided.
Either way, sir, he definitely can't be sitting and deciding that appeal. That application.
It's a stay application, my lord.
Whatever, sir. Why should he decide a stay application?
They
are rejecting it. The stay application was rejected.
No, my lord. Stay application was granted. It was prima facie found that he has a case and it was granted. And in any case, my lord, he has decided it as a quasi-judicial authority, not as a statutory officer, because a revisional authority has decided it. In a stay revision, my lord.
In that J. Mahapatra's case, that books...
1 minute. 1 minute. No, 1 minute. Mr. Padi, you are saying that the impugned order is in his favor.
No. Not the what he is saying, my lord, I mean, Lord Senior is submitting. During pendency of the appeal before the tribunal, he has moved an application for stay of demand before the Additional Commissioner. And that application has been allowed. Now that Additional Commissioner has
authored that order of the tribunal dismissing my...
Don't interrupt him.
Yes. Sorry, ma'am.
Now, my lord, that Additional Commissioner happens to be the accounting member before the tribunal. So in my humble submission, my lord.
No, that additional commissioner's order, is it in favor of the petitioner or is it against?
Additional commissioner's order is not under challenge, my lord. It is in favor of the dealer. That is not under challenge, my lord. So it is the order of the learned tribunal that is under challenge. During of the application before the tribunal, he has moved an application before the additional commissioner for stay. That stay was granted. He is no acted by that. So the appeal order, the first appeal order, that was not passed by in fact, this member. So it's an offshoot in a stay revision that accounting member has decided.
No, what happened to the appeal?
That appeal now
he was dismissed. Second appeal, sorry for the interruption, and with excuse to my learned friend, the second appeal was authored by the person who had passed the stay order. And while sitting in the second appeal forum before the Orissa Sales Tax Tribunal, he has decided against me and other two members agreed to his order. That is my case. That it is not the doctrine of necessity. He could have said that, no, I have already seen that file and I have passed an order, whether against me or allowing me my stay order, but I cannot see it in the or second appeal. And J. Mahapatha's case,
if your lordship would see the
Para 17 of the judgment,
that is the stay order that has been decided by this additional commissioner and the appeal before and the revision before your lordship, these are completely two distinct proceedings.
No. Of course, they are distinct proceedings, sir. They are distinct proceedings only in terms of that being a Revenue Divisional Commissioner stay order, this being the tribunal's order. But the person is the same. The author of the stay order there is the author of the tribunal's decision here.
No dispute over that, my lord.
And therefore, since he had participated at one stage of these proceedings in a lower capacity, in a lesser capacity, he should have recused.
But that order, the stay order was not.
No, let us now see in terms of a district judge and a high court judge. All right.
Yes, my lord.
Let's say the district judge has passed an order, whichever, favor or against, at the stage of an appeal in the high court. Now that district judge has become a high court judge. Will he decide the same appeal?
Had it been my lord, that case, I would not have uttered a word. My lord, here, my lord, the example can be given in my lord. If the learned judge has heard the bail application, he cannot hear.
He must be aware. See, the thing about bias is this: justice being seen to be done. Yes. All right. In whichever capacity, whether a quasi-judicial capacity or judicial capacity or whatever, he's aware of the facts, and it's the very same case. It's not some other case.
I bow down to your lordship, my lord. If I can give an example.
I'm surprised you're defending it so stoutly.
No, my lord. If what my learned senior is submitting, if the learned judge has decided the bail application, he cannot hear the appeal.
No, sir. You're mistaken on this again. Suppose he decided the bail application as a district judge.
Yes, my lord.
Now he's sitting as a high court judge. That will have a bearing. It's in the same proceedings.
We cannot.
In the same proceedings. In the same proceedings, sir, in different capacity.
But here, my lord, the proceeding is not the same. The stay order is not.
Sir, the stay emanated from these very proceedings. I'm very surprised that you're arguing like this. The stay did not emanate from different proceedings.
For the same year?
No, same proceedings. It is when this appeal was pending that the stay in connection with this appeal went before that man.
Yes, my lord. That's
Your lordship is absolutely right. He should have refused. He should have refused.
That's right.
Himself.
I'm surprised Mr. Padi is defending it so stoutly. But anyway, he's doing his job. All right. So now we have to write a long judgment on something that will go back and might get Mr. Rai's client into trouble.
Your lordship,
at least, my lord, I'll be much obliged if he gives me some fees. Much obliged.
All right. We'll write the detailed judgment. It goes back. So the appeal will now be listed before the tribunal on. I don't know, the tribunal is not closed for the holidays.
Can it? No, they don't have any summer days.
Oh, I see.
June, my lords, kindly post it in June.
All right. 6th June.
Right.
All right. 6th June 2022.
Obliged.
Is it air conditioned or not? The tribunal is air conditioned.
Yes, conditioned. Now, because of your lordship's giving.
Because with your arguments, you'll make it more uncomfortable for them.
No, by your lordship's participation, your new dimension have been given to these lower authorities and inferior tribunals.
All right. The appeal is, the revision is allowed. You say admit the following questions of law is framed, all that will dictate. The revision is allowed. The impugned order of the tribunal is set aside. The essay number 1727 of 1991 will be listed for directions before the tribunal.
Question number 1, I believe. On question number 1, I believe.
Right, question number 1 alone. Yeah, on 6th June 2022. This man must have retired by now.
Yes.
Long back.
Pastor matter special weekly list item number 15.
Much of.
Yes, Mr. Body.
15, my lord. Here, the file is missing, my lord.
Okay. Mr. Body says that the file is missing. Dismissed with liberty to revive the petition as and when the file is traced. Yes.
Pastor matter item number 17.
Name, please, your lordship. The question of law.
What's the tax effect, sir?
The tax effect is 3,77,000.
All right. What's the question of law?
That is set out in the prayer, at page 6.
Lesser percentage of tax is payable.
Yes, madam. It's an assessment under the Central Sales Tax Act, madam. Here, admittedly, the petitioner, the dealer, could not produce C declaration forms in respect of certain interstate sales.
All right.
So, as per section 8(3)(b) of the Central Sales Tax Act, he has to discharge tax on that as per the Local Sales Tax Act. Now, in respect of that material, the learned assessing officer.
1 minute. Opposite party is served or not? Opposite party is not served, sir. Oh, the tribunal is directed to submit statement of facts on the following question. And that statement of fact never came. No, statement of the case is received, placed below for orders. Sir, after 11 years, 14 years, sending notice is no point. We leave the question open. We say, yeah, in the present petition on 2nd May 2000, the tribunal is directed to submit a statement of facts on a question regarding rate of tax payable. Stop. Unfortunately, no, full stop. Thereafter, on 27th January 2009, that is nearly 9 years later, it was directed that paperbooks shall be filed. Full stop. However, till date, the paperbook has not been filed. Consequently, leaving the question of law open for decision in some other case, the revision petition is disposed of. Yes.
Pastor matter item 19.
My lord, fresh so cause notice and so could not be issued. Requisites.
Requisites are not filed for over 14 years now. The court does not propose to grant any further indulgence. The revision petition is dismissed. Yes.
Pass to matter item 37.
May I please?
List of dates.
That here is a case where the order passed by the member board of revenue. My first submission before your lordship, that with all humiliation I am saying that the order passed by the member board of revenue is totally without jurisdiction, and he has, while passing the impugned order, he has changed the basic structure of the state abolition law.
Let's go on with the matter.
Yes. Your lordship, I have prepared a.
Yeah, we've got it. Yes.
That chart with the exhaustive note of submission.
Yes.
The petitioners are the purchaser from the recorded owner and have filed this writ application challenging the illegal and erroneous order dated 17/8/2019 passed by the member board of revenue in OEA revision case number 11 of 2005.
So don't read out the notes at first. Tell us the facts.
Yes, ma'am.
What are the facts?
Before going to the facts, Lord.
Oh, it's there from page, page 12, you've set it out. Let's read that.
Yes, ma'am.
Genealogy.
Yes, ma'am. I have given the genealogy. Lord Bhagavan Rayat Singh was the common ancestor, and the property was recorded. Your lordship, kindly see the second branch. The property was recorded in the name of Lakshmi Janardhan Mandhata, and that is annexure 1, Lord, under the status Sthitivan Babat Nijot. So therefore, it is the occupancy, he is the occupancy tenant, it is the Sthitivan property of that person. And after his death, by succession, it went to the Nabin Chandra Singhdeo. Narayan Chandra Singhdeo was the adopted son of Narayan, was adopted, and so after the extinct of this branch, my lord, by way of survivorship, it go to Nabin. But that is the preliminary fact, my lord. It go to Nabin, and in a partition suit, family partition, this was allotted in favor of Nabin. So therefore, they are continuing in 1927-28. This property was recorded under Sthitivan Babat Nijot. Thereafter, your lordship can see annexure page 13. 1927-28, CS Khata number 67, plot number 327, area 75 decibel, was recorded in the name of Radha Prasad Bhagat and others, the ex-intermediary of Kothadesh's estate, under whom Lakshmi Janardhan Bir Singh Mandhata was the occupancy tenant. In respect of the land in dispute, the status of the land was Sthitivan Babat Nijot. The CSROR further indicates that in respect of the disputed khata number 67, including the present disputed plot, the rent was fixed at the rate of ₹25. 13 anna was fixed towards cess. In view of the fixation of rent and cess by the intermediary, the character of the property was undoubtedly the Sthitivan property of Lakshmi Janardhan Bir Singh Mandhata from its very inception. In 9/9/2019, during the lifetime of Radhamali and her husband Prithviraj, as no child was born from their wedlock, they adopted Narayan Chandra
This can't be the dates. This is a misleading way of preparing list of dates. Under a date of 9/9/2019, just come back to that page, page 13. You have put a date of 9 September 2019.
That is a mistake.
Mistake?
That is a mistake.
What is the date?
The date is that must be 19. That must be 19. 1919, 2019.
How can it be, sir? The earlier date is 1927.
1919 now.
Sir, after 1927, 1919 will come. You will go baskwards.
Given the
sir, you will go backwards. After 1927, you'll go back to 1919.
Your lordship can skip over that date.
Why should we, sir? First, let's be clear on facts. What is this going on?
We have narrated, your lordship can see them or repeat something. That may be a mistake in my.
We are in a final hearing.
Yes, ma'am.
Please be clear about list of dates, facts. When did this adoption take place?
9/9/1990.
Sir, it can't be, sir. The earlier date is 1927. You are going backwards.
No, I am not going backward. 1927, the record was continuing in the name of that Janardhan Bir Singh Mandhata in the Sthitivan status. The property was recorded. Your Lordship can see for a moment answer 1 million.
Sir, when we were in the bar,
yes,
you are getting so agitated as if I have made a mistake.
No.
When we were in the bar,
Your Lordship does not.
This is what my understanding is.
I am not.
No. You are very enlightened. When we were in the bar, if I had to prepare a list of dates and I gave my senior first date is 1927, next date is 1919, he will throw the paper at me. He will say, "What, you're telling me that 1927 is earlier than 1919?"
No. That I should have recorded. I should have first recorded 1919.
What is that to show 1919 this happened? What is the document?
The document.
No document.
Answer to deed of acknowledgement of adoption dated 9/9/1919, duly attested by the assistant consolation officer. That is the deed of adoption.
Sir, we are now on 9/9/1919. According to you, 9 September 1919.
Yes.
They adopted Narayan Chandra Singh Dev.
Yes.
Where is the document to show this adoption?
Annexure 2.
Annexure 2?
Yes.
Let's see the annexure 2.
Annexure 2. That is in vernacular. That is annexure 2 at page 18.
Okay, they adopted and then what happened?
After adoption, Narayana became the successor of the property. Narayana became the successor of the property in 1927-28 when the record of right was prepared. It was in the name of Lakshmi Janardhan Mandata. That was continuing.
Sir, you have a special skill for list of dates. Okay. 1927, next date is 1919. Third date is 1982. Come to page 14.
Bismillah.
Fourth date is 1952. I am sure if I ask you a question, you will get very upset with me now.
No. Never.
No,
never I will be upset with
what never? In a high court, you are giving list of dates.
Yes,
first date is 27, second date is 1919, third date is 1982, fourth date is 1952. Fourth date is 1952.
Why I am giving that in this manner?
Don't call it list of dates.
I will correct that list of that, but it is your Lordship can see my.
Basically, what you are saying is you are two high court judges. You do not have enough work. You sit down and do all the work. I will only come and argue matter. You better sit down. You figure out whichever sequence of dates.
You have
very little work. You are only wasting time. You are having a lovely time.
I may not
you better do all this work.
I have not concealed the facts, but what I have.
We are very obliged to you, sir. We are extremely obliged that you have not concealed facts.
Your Lordship, kindly permit me for a moment. There is some anomaly in the placement of the dates, Lord. But what happened? 1953. Why I am saying? Why I am giving this in this manner, Lord? Because how the property has succeeded from the real owner to the present, the vendor of the petitioners, Millard. For that purpose, I have given in that manner, Millard. Millard, the 9/9/2019 is a mistake. I should have written 9/9/2019 first. Thereafter, the 1927-28 record of right. Thereafter, I should have gone to by mentioning that the state vested to the state in 1952-53. Thereafter, 1982. Yes. But there is some anomaly in the dead chart.
Yes.
But what happened that in this manner, the property came to Navin Chandra Singh Dev as the successor of the Sthitivan right.
Sir, it will not, sir. Once it is vested in the state, nothing will come to anyone.
That your lordship.
This is the whole problem. That is why your list of dates is all jumbled up.
No, I have not jumbled up.
No. Then you have to start explaining. See, once the estate is vested, OEA Act is passed.
Your lordship, kindly permit me for a moment. There is no question of vesting of the tenancy in the state. There is no question of vesting of the tenancy right. The estate will vest. I will rely upon one decision of this full bench of this honorable court, that volume 15, 1980 CLT. Their lordships have distinguished and reversed two earlier judgments and have said that only the estate will vest, intermediary interest will vest to the state, not touching to the tenancy right. Vesting upon 1962 Supreme Court.
Just logic, just pure logic, sir. Just pure logic. 1 minute before you go to judgments.
Yes, ma'am.
A is the landlord, B is the tenant.
B is the tenant.
By a statute which is passed, A is no longer the landlord, state is the landlord.
State is the landlord.
How will the tenancy between A and B continue, sir?
Let A and B continue. So therefore,
there is no A.
Let that for that purpose.
So there has to be a fresh in a non-state intervention. There's something called atonement of tenancy.
I will convince your lordship. If the estate has been vested, for that purpose, for that objective, Section 8(1) has been enacted in the OE Act. Section 8(1) say that if a person is continuing as the tenant under the intermediary, he will continue under the same status, same restriction with the government.
How? There is some condition to be fulfilled for that.
Government will only make an administrative recognition.
No, sir. The earlier, just tell us that Mr. Mohanty knows this.
That recognition is required. And if your lordship will go to this aspect, may I take a single moment of your lordship to show a particular page 112 of the imperial.
No. What is that? Ekapadia something?
Ekapadia and tenant. There has to be ekapadia. Now here is a different case. Prima facie, your lordship is to examine what your lordship has pointed out at the first instance. This adoption issue, and he is standing on the foot of his vendor. Vendor is Nobin. Nobin is not before your lordship. Nobin has suffered the order. He was before the Board of Revenue. Now, what is the finding of the Board of Revenue? That your sonship is a disputed question of fact. It is not acceptable, and the civil court can take a call for. But what I beg to submit, when your vendor's status as the son of the ex-intermediary has been seriously disputed, and the learned court below has said that you have to take shelter of the civil court for getting that, I will take only 2 minutes. Para 13 of the impugned judgment at page 112 of the retrospect, in support of his claim, so legal errors.
Lordship, kindly permit me for a 1 minute. Let me complete my learned friend.
Was there an atonement of tenancy? Is what we want to see, sir. Was there an atonement?
No, there is no ekpad. Yes, there is no such
atonement and tenancy. Your lordship, I will go to that. Your lordship, kindly see for a moment 1993 153. Because there's a lot of
unless we are clear on facts, sir. We can go to judgment. You have to be clear on facts.
Yes, Stitivan tenant, no ekpadia is necessary. For a Stitivan tenant, no ekpadia is necessary. Nothing is necessary.
That is also discussed.
Please wait. The Orissa Tenancy Act clearly provides that if a person is a settled right for 12 years and continued in possession, then he will acquire the right of occupancy over that land. And the right of occupancy is an heritable and transferable right that can only be taken up by the procedure which has been provided under the Orissa Tenancy Act.
No. That occupancy is without paying any rent, anything.
No. Rent has been fixed. That has been mentioned in the record of right. And I am paying the rent. Even I have not paid the rent for 100 years. Then also my Stitivan right will not go. That is the law. And what the authority will do, they will initiate a proceeding before the civil court for realization of rent. If I have not paid the rent, they will go for auction of the property. Only by auction, the property will be taken up. The Stitivan right. Stitivan right cannot be taken up for non-payment of rent or anything. That is Section 29 of the Orissa Tenancy Act. Your lordship can see for a moment. The lordship can see Orissa Tenancy. how a Stitiban tenant will be evicted from his land.
Yes.
Well, Lordship can see section 29. Before section 29, your Lordship can see what is how this Stitiban right accrued to a person. That is at section 23 of the Orissa Tenancy Act. Occupancy rights. Chapter 3 begins with the occupancy rights. Your Lordship can see section 23. Definition of settled right. Every person who for a period of 12 years, whether wholly or partly, before or after the commencement of this act, has continuously held as a rayat land situated in any village, whether under a lease or otherwise, shall be deemed to have become, on the expiration of that period, a settled rayat of that village. Then your Lordship can turn to section 24. Section 24, settled rayat to have occupancy right. Every person who is a settled rayat of a village within the meaning of section 23 shall have a right of occupancy in all land for the time being held by him as a rayat in that village. Every person who being a settled rayat of a village within the meaning of section 23 held land as a rayat in the village at any time between the 10th day of September 1891 and the commencement of this act shall be deemed to have acquired a right of occupancy in that land under the law then in force, but nothing in the subsection shall affect any decree or order passed by a court before the commencement of this act. Then your Lordship can turn to section 29. Protection from eviction except on specified grounds. An occupancy right shall not be ejected by his landlord from his holding except in execution of a decree for ejectment passed on the ground A, that he has used the land comprised in his holding in a manner which render it unfit for the purpose of the tenancy, or B, that he has broken a condition consistent with the provisions of this act and on breach of which he is under the term of a contract between himself and his landlord liable to be ejected. Except by a court of execution of a decree, he cannot be evicted from the land. That is the law. And if and that has been, this provision has been summarized in series of judgments of this honorable court.
No, what is the effect of the Estate Abolition Act on this? What happens when the land vests in the state?
Land vests with the
from all encumbrances.
With the state. Your Lordship, kindly see for a moment the volume 50 CLD, and it has been elaborately dealt with in the by the full bench. Only I will place paragraph 12 of that judgment. I did not burden you with your Lordship all the paragraphs. Your Lordship, can you see for a moment section paragraph 12. We shall now proceed to examine the correctness of the two single judge decisions, being Malyabudhi Thakurani and another versus Udanath Parida and others, and Pitha Sitama and others versus Ramachandra Mahapatra. In the first case, in paragraph 4 of the judgment, the Lord and single judge referred to the bench decision in the case of V. Krishnarao Dora and others versus Kotini Sitaram Dora and others for the proposition that if an occupancy right, your Lordship can mark, if an occupancy right did not contest the claim of an intermediary in khas possession, after due service of notice, the settlement made by the collector under section 7, section 7 means under section 7 of the OE Act, in favor of the intermediary in khas possession would be valid. We have grave doubt about the correctness of the aforesaid ratio in the bench decision in Krishna Rao Dora case. In the case of Kumar Bimal Chandra Sinha, that is the Supreme Court judgment. In the case of Kumar Bimal Chandra Sinha, deceased, and after him, his legal representative and others, versus State of Orissa and others, the Supreme Court indicated that the interest of a riot was not touched by the act. That is the way act. Touched by the act. And if there was an occupancy tenant on the property, even if the collector made a settlement in exercise of his power under Chapter 2 of the Abolition Act, there could be no scope for the conclusion that the tenancy right of the occupancy tenant could be taken away. The settlement in such a case would be beyond the jurisdiction of the collector. And even if upon notice the occupancy tenant does not appear, does not enter contest, his right in the property cannot be affected by any action of the collector. So therefore, my humble submission before your lordship, and what is the status of a Stitivan Babat Nijot Miller? That has also been dealt with in 1993, one Weller. The lordship can see only a passage I will show to your lordship. Yeah. That paragraph 2. At page 155, paragraph 2. That what's the bottom your lordship can see. I will give you. The petitioners were admittedly, your lordship got it here.
Yes, yes.
The petitioners were admittedly occupancy tenants on the land as per the record of rights, finally prepared and published under section 116 of the Orissa Tenancy Act on 30/12/1927, showing the land to have been recorded as a Stitiban Babat Nijot. Your lordship can pausing for a moment. Your lordship can see Annexure 1. My Lord Justice Patnaik will see that because it is vernacular. Our property has also been recorded as Stitiban Babat Nijot. Nijot with the Dharja Jama. Here is also the job rent has been fixed. Dharja Jama and local cases which as Dhulibaga Moyases and the predecessors in interest of the petitioner shown in column 4 of the record of right as tenant. Though a lot of argument were advanced by Mr. Mahapatra, appearing for the opposite part number 4, contesting the Stitivan status of the petitioners as per the record of right, yet he ultimately fairly considered that the petitioners were the occupancy tenant of the land, but contended that they had surrendered their holding. Here is not a case of surrender. Holding long prior to the vesting, and that on the basis of the khas possession of the opposite part number 4 at the intermediary, the settlement had been made with her. That is not relevant, Lord. So far as the recording as a Stitiban Babat Nijot, and where from it is got, Lord, your lordship kindly see the...
No, but what is being decided here is something else, sir. In this judgment which you have handed over Bhaskar Swine.
Yes, ma'am.
The point being decided is something else.
The point has been decided in that case, Lord. Lord, your lordship's query has been made with that judgment, all the query. Lord. Why I am saying so, Lord? Because so far as the Stitivan right is concerned, that will not touched under the Act.
No. What it says is the civil court is free to now decide that issue. That's what this judgment decides.
Yes, ma'am.
Come to the last paragraph, sir.
Yes, ma'am.
Just come to the last paragraph.
Yes, ma'am. Paragraph 9, ma'am. Paragraph 9 and
10. If you want to read 9 also, you can read, but 10 is...
Yes, ma'am. Paragraph 9 is the most vital. Paragraph 9. One submission has been made with great tenacity, not since the occupancy tenant had a right to come before the civil court, assailing the decision of the OA collector. his such right cannot be taken to have been wiped out, and that the consultation authorities, being the substitute of the civil court in that regard, should be held to have the authority to examine the issues. The submissions does not find force with me. As has been, what is the reason being, but as has been seen earlier, it is open for the legislator to exclude from the gauge of the civil court also decisions of the special tribunals on question of preliminary or collateral or jurisdictional facts. Hence, even if the decision as to whether there was an occupancy tenant upon the land on the date of vesting is taken as a primary fact decided by the state abolition authorities, while deciding the fact of the intermediary being in khas possession on the date of vesting or not, as has been decided by the full bench in 80 CLT 393, yet it is to be held that in providing for the exception under section 51(1), the legislature has intended to grant finality to the decision of the OEA collector even on such primary facts. As such, either where the occupancy tenant has appeared and contested the claim of the intermediary and has lost before the state abolition authorities in a section 7 proceeding, or has not responded to the public notice issued under the first proviso to section 8A2 of the OEA Act, and the decision has been rendered by the OEA collector upholding the claim of the intermediary, that must be taken to have achieved finality and is not liable to be questioned any further before the consultation authorities. The decision in 63/1987 CLT relied upon by Mr. Pal has no application to the facts of the case.
I don't need to read all this.
Our
Come to Paraton, sir. Come to Paraton.
Yes, ma'am. The conclusion reached as regards the finality of the decision of the state abolition authorities under section 7 is, however, subject to one exception so far as the jurisdiction of the civil court is concerned. Section 31(1) provides that where the landowner is allotted his original land holding, either wholly or part, in the final consolidation scheme, his right, title, interest, and liability in such holding or part thereof, as the case may be, shall remain unaffected. Thus, even though in respect of the chakkaj allotted to a landowner after the final consolidation scheme, there is creation of a new right in the chakkaj, yet the liability of landowner in respect of any land allotted to him under the final scheme will continue unabated if he was the owner of the chakkaj also originally, and hence if the land which had been settled with the intermediary under section 7 is re-allotted to him either in whole or in part, the respect of that land, either wholly or in part, as the case may be, vis-a-vis an occupancy tenant, shall continue unaffected. And hence the decision of the OEA collector
So you will have to go, yes, decision of the OEA collector will still
remain open to question before the civil court.
Correct. So
Yes,
what therefore has to happen is, if you are asserting that you have a Sthitiban status, you are this Baban thing, Nijot.
Sthitiban Babat Nijot.
If you are claiming that, sir.
Yes, ma'am.
Notwithstanding the OEA Act, you can go before the civil court.
Let us go before the civil court. Here is a case, Lord. Your Lordship, kindly.
That is what this case.
Kindly give you 1 minute to explain that decision.
No, you'll get more than that, sir.
Yes, ma'am.
No, but this decision therefore says, if you are claiming all that is under the consolidation, you have already perfected your Sthitiban status.
Yes, ma'am.
And that cannot be disturbed by the OEA Act.
Yes.
This decision says you are free to go to the civil court to assert that, and the civil court will decide it.
No, free to go to civil court in the context the honorable court has said that it is a dispute between the intermediary and the
state can never be called an intermediary. State is not called an intermediary.
But the intermediary, there is a case. The honorable court has upheld that if a person is continuing as an occupancy tenant, the OEA Act has no application.
No. That you will have to go and assert that before a civil court, sir.
But the civil
court,
court,
automatic.
If my right has not been decided by the consultation
because of the intervention of law, there is an Estate Abolition Act.
Then in that case, I will.
You have a new owner in the place. The new player is the state.
Yes, ma'am.
But
I am understanding.
Vis-a-vis the state, if you have to assert a right, tracing it back to your Sithiwan status under the Consolidation Act,
yes, ma'am,
or on the Orissa Tenancy Act, you have to go to the civil court to assert that.
The civil court, if I certainly would have gone to the civil court if there is no consultation proceeding. Because during that period, Lord, when the order was passed in my favor, the distinguishing feature in this case and my case is, Lord, when the order was passed in my favor in 1985 for acceptance of the rent, thereafter consultation proceeding, thereafter consultation process started in the area. And I filed objection under section 9(3). In this pausing for a moment, your lordship kindly see the Consultation Act. Section 4, section 51 read with section 4(4). Well, Lordship, kindly see for a moment, section 51.
51.
51. Thereafter, I will go to the section 4(4).
Yes.
Bar of jurisdiction of civil courts, notwithstanding anything contained in any other law, for the time being in force, but subject to the provisions contained in section clause 3 of section 4 and subsection 1 of section 7. All questions relating to right, title, interest, and a liability in land lying in the consolidation area, except those coming within the jurisdiction of the revenue courts or authorities under any local law for the time being in force, shall be decided under the provisions of this act by the appropriate authority during the consolidation operation. So therefore, with my interpretation to this provision, Lord, because my occupancy right is not touched under the Revenue Act, under the Estate Abolition Act. So, Estate Abolition Act, it cannot be said that the Estate Abolition Authority has the jurisdiction to decide my right. And thereafter, I will go to the fact on the date the Consolidation Authority decided my right, Lord, whether any estate abolition proceeding was pending or pending before any of the authority. So therefore, the Consolidation Authority has the power to decide the question of my question of right, title, and interest if it is not coming within the purview of any revenue authority. Your Lordship kindly see the section 4(4). Section 4, subsection 4 of the Act.
Yes.
First, before going to the section 4, I am, for your Lordship's convenience appreciation, I am placing that subsection 1. 4. Effect of notification. Upon the publication of the notification issued under subsection 1 of section 3 in the official gazette, the consequence as hereinafter set forth shall, subject to the provisions of this act, ensue in the consolidation area till the publication of the notification under section 31, that is the closure of the consolidation proceeding, or subsection 1 of section 5, that is the suspension of consolidation proceeding. Either of two notification is made. Till that date, the Consolidation Authority has the power to decide, your Lordship kindly see, then subsection 4. Every suit and proceeding for declaration of any right or interest in any land situate within the consolidation area, in regard to which proceedings could be or ought to be started under this act, which is pending before any civil court, whether of the first instance or appeal, reference, or revision, shall an order being passed in that behalf by the court before which such suit or proceeding is pending stands abated. If any proceeding is pending during the consolidation operation, that will stand abated and the Consolidation Authority will decide the question of title. Am I clear, Lord? So therefore, Lord, now coming to my case, your Lordship kindly see. At the time, in 1965, my tenancy right was recognized by the state, and the state passed the order for payment of the rent. Thereafter, I paid the rent. And your lordship kindly turn to Annexure 4. Annexure 4 at page 76. And before going to that order, your lordship kindly see for a moment section 9(3) of the Consolidation Act. Section 9(3) of the Consolidation Act. Let 3. First, under section 9(1), the land register will be prepared, mentioning the name of the recorded owner. Thereafter, if any person, any objection with regard to the preparation of that record and pertaining to the relating to the title of the property, then he will file an application under section 9(3), objection. Your lordship kindly see section 9(3). Any person to whom a notice under subsection 2 has been sent, or any other person interested may, within 30 days of the receipt of the notice or of the publication under subsection 1, as the case may be, file before the Assistant Consolidation Officer objection on the correctness of the entries in the record and the extract furnished therefrom, or on the statement of principles or relating to partition. So therefore, this provision enables the person to file the objection relating to that property. If there is contest, then it will go to the Consolidation Officer. Section 10, your lordship can see. Section 10 of the Act. Disposal of objection by the Assistant Consolidation Officer under subsection. If there is conciliation between the parties, then Assistant Consolidation Officer will decide. Then section 11. If there is a contest, then disposal of objection by the Consolidation Officer.
No, but in your case, all that doesn't arise, sir.
Lord, because it is arise. Why I am saying, Lord? Your lordship kindly for a moment appreciate what I am saying. Lord, my right was decided and the government passed the order. The State Abolition Collector recognized my Stithwan right and passed the order for payment of the rent in 1985. That is borne out from the order which are given by the state in their counter under annexure. That is the order dated that is the order dated 2/1/85 at running page 130 million. That the state accepted the rent from me. Thereafter, I went to but the land was continuing in the name of the state because after vesting below. So therefore, I filed the objection before the Consolidation Officer under section 9(3). State contested in that objection case. And the Consolidation Officer, your lordship kindly having the jurisdiction over the matter, take the witnesses, the evidence, all the documents were examined. Thereafter, the Consolidation Officer passed the order that my vendor has acquired this right of occupancy, and by purchase, we have come to the status of the occupancy tenant. So therefore, our right was declared. This order has never been challenged. And this order appears to have been challenged under section 12 of the Consolidation Act. They have not challenged. No revision has been filed. Straightway, 38B application was made with the reference of the collector. But another question arises for my lord's consideration. Since the Consolidation Authority has decided the title, when the consolidation proceeding was in vogue, so therefore, that is a document of title. And that question cannot be agitated now before the civil court. The section 51, subsection 2 is a bar. And in these circumstances, the order which has been passed, your lordship kindly see the nature of the order passed by the OEA collector, that has been annexed to the order of to the counter of the state. He has only recognized our tenancy and directed for payment of the rent with 3 years rent as a salami, my lord. If such an order is passed, my lord, the division bench of this honorable court has hold 63, 1987. Your Lordship, kindly see for a moment this judgment. And repeatedly it has been decided. The Lordship, kindly see. I am not going to that paragraph 6 that has been quoted in the Placidum. The order of the Tahsildar was under the lease principle and not under the provisions of the Orissa State Abolition Act. Therefore, section 38B of the Orissa State Abolition Act cannot have any application. Cannot have any application since the settlement in question was not under the provisions of the said act. Here in the executive instruction, why the Lordship has said in section, your Lordship can see since here the salami has been fixed. The salami is not provided under any of the provisions of the act. That has been taken in note of in this judgment. Once the salami has been fixed, 3 years rent as a salami has been fixed, it is not a settlement under any of the provisions of the act. That has been decided in this judgment. So therefore, section 38B has no application. So therefore, my humble contention before your Lordship that the member board of revenue has completely exceeded its jurisdiction and has passed the impugned order while the dispute has already been adjudicated by the competent consultation authority, and he should not have gone to the question that it is the property has been vested. First, he has committed the mistake by saying that though the property has been recorded under the status Stitiban tenant, that has been vested to the state. That is a fundamental error he has first committed, and he has proceeded with the footing that even the property has been vested to the state and it is a state property. And for that purpose, he has said that the order passed by the consultation authority, though he has no jurisdiction to touch the order of the consultation authority, that the consultation authority has gone wrong in saying that the property has been settled in their favor. In this context, I am also relying upon another judgment of the Honorable Supreme Court. A perimeter provision of the Consultation Act was taken into consideration by the Honorable Supreme Court and have said that once the Consultation Authority has decided the question, it cannot be re-agitated again before any revenue authority or the civil court. That is 1985 Supreme Court, page 39. By relying upon another decision of the 1974 Supreme Court, 1920. Your Lordship, kindly see at page 47, paragraph 16. That the second contention of the respondent, which found favor with the High Court, was that the suit of the plaintiff was barred by Section 49 of 1953 Act. Section 49 reads as under, notwithstanding anything content, as if the Section 51 of our Consultation Act. Notwithstanding anything contained in any other law, for the time being in force, the declaration and adjudication of right of tenure holders in respect of land lying in an area for which a notification has been issued under subsection 2 of section 4 or adjudication of any other right arising out of consultation proceeding and in regard to which a proceeding could or ought to have been taken under the Act shall be done in accordance with the provisions of the Act, and no civil court or revenue court shall entertain any suit or proceeding with respect to the rights in such land or with respect to any other matter for which a proceeding could or ought to have been taken under the Act. The admitted fact are that the authority under the 1953 Act, that is the Consultation Act, allotted the plots in question to the respondent. It may be that the decision may appear to be erroneous in as much as it was found on the decision of the additional commissioner in favor of the respondent, which are reversed by the Board of Revenue. The question is, once the allotment under 1953 Act became final, would a suit lie before the civil court or revenue court with respect to right in land or with respect to any other matter for which a proceeding could or ought to have been taken under the 1953 Act. Your Lordship, kindly pausing for a moment, I am bringing to your Lordship's notice that once the Consolidation Authority passed the order, the forum provided under that special act to challenge that order under section 12, and if any party will not succeed in appeal, they will file the regular revision under section 36. That is taken note of by the Honorable Supreme Court. When the village in which the plots in dispute are situated was put into consolidation was not made clear to us, but the statutory authorities and the High Court, while dismissing the appeal of the appellant, had noticed that the village was put into consolidation several years before the suit from which the present appeal arises was filed, and village was notified in the year 1958. Once the village was denotified, the allotment made under 1953 Act became final. The final allotment cannot be questioned by the suit before civil or revenue courts in view of the bar contained in section 49. This is also that this view has been taken by relying upon 1974 Supreme Court, page 1920. The Lordship can see that judgment. That is under the UP Consolidation Act. But I need not place that paragraph here, you can see that the placitum. Proceeding under UP imposition of ceiling on Land Holding Act cannot take place during consolidation operation under UP Consolidation Holding Act. Proceedings under the Ceiling Act abate under section 5(2) of the Consolidation Act on commencement of consolidation operation under that act, though they can be resumed after the completion of such operations. So therefore, all the rights which the Consolidation Authority is vested with the power to decide, if they have decided that it is not a case that they have exceeded the jurisdiction, or it is not coming within that their jurisdiction, they have passed the order. They have passed the order perfectly within their jurisdiction. And if any person is aggrieved by that order, he could have filed the appeal before the appropriate authority. They have not chosen to file the appropriate authority. And I have also placed before your Lordship how the order passed by under section 38B is completely without jurisdiction. So in these circumstances, my humble submission before your Lordship that what
is the finding of the Board of Revenue, member Board of Revenue with regard to the consolidation order?
Nothing.
There is no mention.
Not touched. Only one line order, your Lordship kindly see. Only one line order. Your Lordship kindly see paragraph 22. Paragraph 22 of the impugned order. That I am placing from paragraph 22 because he has given he has recorded his finding from paragraph 22. He has not touched, and he has not even whispered about what is the legal effect of that order. But I'm just but not said anything. about that consultation, the order. And your lordship kindly see, I'm just placing this portion of the order to only to appeal to your lordship's judicial conscience. Your lordship kindly see in what manner he has dealt with. Your lordship kindly see the paragraph 24. The last portion I am just saying. Last portion. How he has dealt with the Stitivan right of a person. The lordship kindly see. Only the last sentence I am placing here at page 117 of the impugned order. My place, Lord. If the Nijot status, your lordship got it, if the Nijot status is terminated, the long-term occupancy right that is Stitivan Babat is also terminated. Where from that he got it? Which law provides that? Your lordship, see, I am asking a question to myself. Lord. On abolition of the state, ex-state, the Nijot status was terminated. The Stitivan Babat status was riding on the Nijot status. Your lordship, see. Therefore, the status of Stitivan Babat was also terminated. That is why the suit land had vested in the state. This is the total the reasoning given about the vesting of that property law. Your lordship, kindly see for a moment. I will not be excused myself to if I have not placed before your lordship that Daljil's report about the Stitivan Babat Nijot. The record of right chapter, your lordship, kindly see. The lordship, kindly see for a moment. Daljil report. All the rights of record before vesting, prior to vesting of the state, emanated from this report. This report was prepared by an ICS officer, and your lordship, kindly see at page 24, the relevant portion. Page 24, second paragraph. When the lordship got it. When settled rights, I have shown to your lordship what is the meaning of settled rights. When settled rights were found in occupation of Nijot lands and are not holding them on temporary leases, they were recorded as having occupancy right in those lands, as laid down in section 55A. The status is Stitivan Babat Nijot. Stitivan Babat Nijot, or if the tenant is not a settled right, Dakhala Sattva Visishta Babat Nijot. If he is not a settled right, then the property would be recorded Dakhala Sattva Visishta Babat Nijot. If he is a settled right, it will be recorded Stitivan Babat Nijot. Once it is recorded as Stitivan Babat Nijot, then it is he is a occupancy tenant, being a settled right. That right cannot be dealt with in this manner. That is my humble submission before your lordship. And much after passing of the consultation order by the consultation officer, this reference was made to the Board of Revenue. The Board of Revenue has not touched the order of the consultation officer and has not said anything. And of course, he has no jurisdiction to touch that order. So my humble submission, by summing up my humble submission before your lordship, first, the Stitivan right, once accrued, that cannot be taken away on the vesting notification, and there is no question of vesting of the Stitivan right on the state by in pursuance to the notification of vesting. My first submission. Once the Stitivan right is created, my second submission before your lordship, once the Stitivan right is created in favor of a person, that cannot be taken away, except the provision which has been made under section 29 of the Orissa Tenancy Act. And section 214 also, your lordship can see. It is a protected right. Under the Orissa Tenancy Act, it is a protected right. That right cannot be touched. Your lordship can see section 240. It is a protected right. Protected interest. It is a protected interest. It is coming under clause D, section 114 clause D, any right of occupancy is a protected interest. It cannot be touched. So therefore, once it's vested and the consolidation authority, after examining they did not accept the rent. Thereafter, we filed the application and the OA collector recognized our right and accepted the rent from us. And thereafter, it came to the consolidation authority. Consolidation authority decided, after taking the oral and documentary evidence, decided the right in our favor. That order was not challenged and straight with section 38B. So the order which was passed in 1985, that is not an order under the Act, that is on the basis of an executive instruction to recognize our tenant's right. That cannot be touched by the Board of Revenue by exercising his jurisdiction under section 38B. So therefore, this is my submission before the Lordship.
Yes, Mr. Monty.
Yes, my lord. The Lordship may kindly have a glance over impugned order at page 112. The learned member Board of Revenue has framed two issues at page 112.
Yes.
First issue is that Nobin Kumar Singh Deo, the opposite partner number 1, is the sole successor of late Lakshmi Nana Bhanja Singh Deo Mandhata. Number 2, the land of Sabik Khata number 1 was recorded in favor of late Lakshmi Nana Bhanja on Stitivan Bhagwat Nijot in the Sabik area, quoting from the settlement report.
Where is this land, Mr. Monty?
Page 112 and inner page 7.
No, where is the land?
Land, details of the land.
No, where is this Moza Adhiya?
It is under Nimapada Tahsil in the district of Puri.
Puri, achha.
Yes.
Okay.
These two issues are
What
framed.
is the extent of land we are talking about?
Pardon my.
What is the extent of land?
87
75 distance.
75 distance.
Only 75 distance.
Near about 1 acre. But my respectful submission is that your Lordship may kindly have a glance. The opposite part number 1 is Nobin Kumar Singh Deo before the member Board of Revenue. He contested the case. He is the claiming himself to be the legal heir of the original Stitivan tenant or any whatever it may be. My learned friend is claiming, and he has contested the case. And the petitioners before your Lordship are purchasers under that Nobin Kumar Singh.
Oh, they were not parties in the member Board of Revenue.
They did not contest. The contestant is Nobin, who was the original lessee, but he did not challenge this impugned order before this honorable court. The purchasers are now coming and challenging the order. Nobin suffered the order, he remained silent, and now the purchasers are before your Lordship challenging the impugned. That is the status.
No. These purchasers were also parties before.
Yes, they are parties to the, but the contestant is Nobin before the trial.
No,
I'm sorry, before the member board.
Opposite party 7. He's an pro forma.
Who
is opposite party number 6? Some Prakash Chandra Manti. Who's he?
2 to 7. There are many opposite parties in the writ petitions. 2 to 7.
No.
And the writ petition only, I think.
No. 6 and 7 are private parties.
All are petitioners before your Lordship. Right from Manjulata till Sudarshan Naik.
No, sir. Come to the cause title of the writ petition.
Yes, my lord. From Manjulata
up to Golap Padihari.
Up to
only Golap Padihari. I think only 10 have come forward.
Golap Padihari. Prakash Mahanti, perhaps.
I don't know who Prakash Mahanti is. Opposite party number 6.
Yes, my lord. Prakash, he is added as a proper map.
What is the stand of 6 and 7? Have they been served, sir? They're not implemented as pro forma parties. They're implemented as contesting parties.
Contesting parties.
What is the status?
They are not appearing. I think no lawyer is engaged.
See, find out who served. They served. All right. So they are subsequent purchasers from 6 and 7.
Like the petitioners. Petitioners are also subsequent purchasers.
Before proceeding, they are the purchaser.
But all of them were before the member, including this opposite party number, this Prakash and Nobin. And Nobin was the main contestant before the member. And he claims himself to be the legal heir of the original. And the finding is, first issue was considered, and the finding is that he is not the adopted son. And this annexure 2 purportedly not accepted by the member. And the member has said that for declaration of your status as the adopted son of the original lessee, you can take shelter of the civil court. And your claim of adoption, this Nobin, is not acceptable. That is first.
Where is that finding? Where is that finding?
Para 13. In support of his claim, as sole legal heir of some RORs have been filed showing the relationship between the opposite part number 1 and late Lakshminandar Singhota, while admitting that he had died issueless. According to
has Naveen's name been entered in the revenue record as this?
No. For the first time in the order passed by the consultation officer, which was found to be a fraudulent order by the member, that he gained over the order, SEO and he got this order, he entered to the picture. That is what the finding of the law. I will straight take your lordship to that page.
No, we were on this finding that he has not proved his adoption. We have para 13. Can you just read that para 13?
13. Yes, convinced that the opposite part number 1 is even a successor. The successorship of this case seems to be complicated. It can be decided in the civil court. But so far as even if the finding seems to be inadequate so far as the status of the, I would like to submit before your lordship. This annexure 2, exhibit 2, my learned friend is relying upon annexure 2, is a plain paper deed of acknowledgement of adoption, not deed of adoption. Deed of acknowledgement of adoption.
I see.
That is admissible under the Hindu Adoption and Maintenance Act 1956, but it is a pre-act that old Hindu law of adoption, because it is in the year 1919. Purportedly, this is a adoption, not a adoption deed, acknowledgement of previous adoption. So this exhibit 2, annexure 2 cannot substantiate the plea of adoption of the Naveen Kumar, his vendor, so as to claim the right of inheritance from the original lessee. That is my respectful submission, subject to your lordship's action. And indirectly also, the learned member board of revenue held there is a complications in this adoption issue, so civil court can decide. Then only, because your lordship may see, this is the infrastructure. Once his vendor is established to be the successor of the original lessee, then other points will follow. Otherwise, that will not follow. And the second point that has also been decided by the
No, because they're all claiming under Nabi.
Under him, all claiming under him. He is not before you. He has not challenged the order. That is the most important factor which I want to praise before your lordship. He has not challenged the order. Although he was a party and he was the main contestant before the member, he did not choose to challenge that order before this honorable court. Now the purchasers are coming. Purchasers are known, and what the trial court, what the learned member board of revenue held in para 25, that the opposite party number 1 has no right and title over the suit land. He had passed no right title in the various.
So since they are the subsequent purchasers.
Yes, my lord. They step into
they are stepping into the shoes of the vendor and trying to establish the vendor's right.
Yes, my lord. And the vendor
has fair enough. That is how it will happen. The vendor may lose interest.
No, vendor was very much contesting before
up to a point, sir. But
yes,
let's say the vendor has received his entire consideration, he may not be interested.
It's okay, my lord. But so far as the finding in the trial court is concerned, why I am submitting this, when the vendor status is under dispute, they are not competent person to establish that, because they are all outsiders. Now, if somebody will say that you are not the son of X, they are not the family members of X. So he has to prove that I am the son of X. So for proving the status of as the adopted son, he is a necessary party and he is to come forward and challenge that finding. That no, it is not a complicated question of law. The finding is wrong. I am the real owner. I am the real legal heir. he has not stated, so he has not challenged that finding. That is why I am submitting that how Nobin's presence in the writ petition as the petitioner is essential. That is up to your lordship to Then so far as the other matter is concerned, the London Member Board of Revenue has whatever my learned friend is now submitting this.
So will they have a locus? See, the question that arises is this.
They have a locus to challenge the order on the ground point of law.
No. Can they have a locus to go to a civil court to say Navin is the truly adopted son?
Yes, my lord. They can say, and implementing the Nobin as a party, and Nobin is to prove the same. Civil court has the wide power and jurisdiction to decide the plea of adoption, either keeping the person in the category of plaintiff or in the defendant. It is not necessary that he should come in the category of plaintiff, because once the lease is before the civil court will frame the issue, and all the affected parties will be called upon to.
So step one and then step two. So step one, if they succeed in showing Navin is the adopted son,
that is my first
then step two, they'll have to say now Navin should be recognized as having holder of Sthitiban status. And therefore under him, we gain this.
That is my first submission before lordship. So far as the second issue, which the learned member Board of Revenue has raised, that has also been discussed. And what has happened, my lord, that this Nobin Kumar, he created a fraud before the consultation officer. That is what discussed in and he gained over the original SEO and got that order, which came into, it's a communal land and the entire villagers are using this land. And when it came to the knowledge of the collector, he filed this 38B application. And if your lordship will, and what your lordship has rightly pointed out, there is no ekpadya. The learned court below has written this in the impugned order. There is no ekpadya, there is no tenant ledger. This concept of babat nijog, that is also discussed in the impugned order, and ultimately came to a conclusion that this order cannot stand on the way. This OEA order that has been quashed by the member. I think there is no legal infirmity in the impugned order, and the member Board of Revenue has rightly passed the order. Like any other order your lordship is coming across in many cases under section 38B is a similar order, but here is a peculiar case where lessee is not before your lordship. That's all.
Only a short reply with regard to this fact.
In fact, I was commenting to Justice Patnaik. This was the main issue you had to address, but you just went completely silent on this issue.
No.
In your entire argument, we didn't hear you utter a single word on this adoption issue.
Adoption.
You never addressed this issue at all.
Adoption question has been decided by the consultation authority. Consultation, my learned friend is not referring to the judgment passed by the CO. That the consultation officer, and in the contest, Nobin has deposed before the consultation officer. And Nobin has said that your lordship can see the order passed by the consultation officer. Consultation officer has the jurisdiction to go into that question of adoption.
No, sir.
And if he has decided even wrongly, can it the member Board of Revenue is the appropriate forum to agitate that question? Member Board of Revenue certainly is not the appropriate forum. If a civil court has passed the decree, if that decree is a nullity or that decree is illegal, that can be challenged before the higher forum, provided under the Act.
No. Which civil court has recognized?
The civil court, the consultation authority, by exercising the power of the civil court, and they have the jurisdiction to decide the question of title. And if he has come to the conclusion that we have the title, Nobin Singh was the party, and all the purchasers were the party.
No. Did the consolidation authority decide that Nobin is the adopted son of its intermediary?
Yes, ma'am. Well, that your lordship can see.
And did the consolidation authority have that kind of a power?
Page 83.
What I have submitted before your lordship, Nobin is not the adopted son. The father of the Nobin was the adopted son.
In any case, his father.
And that we have produced the document, and that has been accepted by the consultation authority.
1 minute, sir.
Yes, ma'am.
The consolidation authority is the consolidation authority the authority to decide the validity of an adoption or the factum of an adoption? Is that the authority to decide the issue?
I will cite one the judgment of this honorable court, Lord, the division bench judgment. When the consultation authority are deciding the question of title, the day and the day out they are deciding the status of the
question
party.
Of title is one thing, sir.
Lord, I am not.
Status of persons is
Lord, I'll give by way of a additional affidavit that judgment before your lordship.
No. For giving a judgment, you don't need additional affidavit. You just hand over the judgment and cite it right now. Why do we need an affidavit for a judgment?
Lord, cite
the judgment, sir.
Lord, I have not brought that. Lord, there is a
division. Lunch hour. We have an excellent library.
Lord, I'll brought that.
Bring it.
Lord, I'll bring that judgment to your lordship's notice. Lord, this honorable court, that is the judgment delivered by Honorable Justice S. Patnaik.
All right.
That the consultation authorities are day and day out are deciding the status of the parties. If they have the authority to decide the question of title, they can very well go into the status of the package. That is the law decided by this honorable court.
All right, show us the judgment.
Lord, I will show that.
No, if actually,
and so far as I am challenging the order of the consultation of the member board of revenue, that member board of revenue had no jurisdiction to touch this issue.
Anyway, sir, where has the consultation authority in your case decided this issue?
That is good. Your lordship may kindly have a glance at page 79.
Let him show us.
79 of the writ petition.
No, let him show. 79.
Examination of witness. Nobin Kumar Singh Dev. He is an objector. He has deposed that originally the suit plot belonged to one Lakshmi Janardhan Biro Singh Mandhata.
Examination of witnesses at page 79.
Yes.
This one was the father of Lakshmi who had one son and one daughter, namely Radhamani Jemadei. Meanwhile, Lakshmi Nana dead, issueless, and accordingly the property devolved to nearest survivor Radhamani, who had three sons, namely Ramo, Krishna, and Narayana. Ramo has no son and adopted of Sarata. Krishna has three sons, namely Nobin, Basanta, and Hemanta. And Nobin was died issueless. After partition, this root property was fallen in his share, and accordingly he has sold the same to the different entities
who are objectors.
Kindly see what document this annexure 2 that was also not produced before the consultation. For the first time, it is being produced before the honorable court. There is no adoption deed produced before the consultation. And again, your lordship may kindly have a glance.
No. This part of the order.
No, it is a part of the order. Is a proceeding of the consultation.
No. So there is no finding. There is no discussion.
Finding nahi, and there is no finding at all. That is my responsibility. This is the evidence record. And again at page 83, examine the document submitted by Sri Nobin Kumar. He has submitted the rent schedule issued in his favor, OES so. The rent receipt submitted by him exposed that he has deposited the salami in the year 1987. One Malati Das has deposited rent in respect of plot whence he has purchased. Sri Sengdos, he has deposited rent so. Examine the arrestees.
At page 83. What is the sum total?
There is no adoption deed produced before it. And another thing is, there was a family partition. Then it came to the hand of Nobin. These are all has to be documented, and that has to be produced before the consultation. And by ignoring all these things, the authority has passed the order. That is why the learned member of Board of Revenue has held that he has gained over the SEO and got the order. There is no material before that. What your lordship? There was no finding. No material regarding adoption and regarding the family partition allotment of that property in favor of Nobin.
Let him answer that. Yes, sir.
Only the finding, I cannot develop it.
Yes.
Only the finding before the consultation authority. Right. Your lordship kindly to page 83. Examine the document submitted by Sir Nobin Singh though.
Right.
He has submitted the rent schedule issued in his favor. Bhai OEA lease case bearing number 367 of 84. The rent receipt submitted by him exposed that he has deposited the salami amount in the year 1987. One Malati Das has deposited rent in respect of the plot. What she has purchased from Sri Singdo, he has deposited the rent on 3388 and 27390. Now, this is the, then your lordship kindly turn to page 87.
Yes.
Your Lordship, kindly say page 89. After going through, your Lordship, can turn to page 89.
89.
Yes. 89. After going through the entire position, the following points are coming to picture for consideration to dispose of the case. Had lease case number so and so, the Tahsildar Nimapada has recommended the case of Prakash Chandra Mahanti for grant of lease. By the OEA case number 367 of 84, the suit plot has been settled in favor of Sri N.K. Singdo, and he has deposited the salary and back rent as per direction of the OEA collector. By the various sale deeds, the vendor, Sri N.K. Singdo, has disposed of the entire property to the different vendors who are the objectors in the case. The ADM Puri has issued his direction to the Tahsildar to verify the genealogy. In a later stage, this Tahsildar Nimapada has submitted his report, which is totally contrary to the record, report. Now, as per definition of Nijot lands, it is clear from the legal point of view that when settled rights were found in occupation of Nijot lands, were not holding them as a temporary lessee, they were recorded as having occupants' right in these lands. As laid down in section 55A, and thus the status of the Stitiban Babat Nijot. It is again well proved on the direction of the Honorable ADM Puri. The Honorable ADM has directed Tahsildar Nimapara to verify the genealogy, and the case is generally excluded from having any objection. In this phase, it is not known and clear before the court as to how the same suit plot leased out to one Prakash Chandra Mahanti and the Lord Tahsildar Nimapada has recommended his case for confirmation of the lease to the collector Puri. Neither the Tahsildar nor his Sri Mahanti has given any satisfactory reply to that to this court. Moreover, the lessee is aimed for hotel industry, and the same industry has not yet been taken up. In this regard, this court has kept contact with the officer of the collector Puri, but there is no response from any quarter. Under such circumstances, I am inclined to believe that the objector, Sri N.K. Singdo, has the right over the property, and accordingly, the following orders have been passed.
So this is not a finding.
Sir. This is the finding. Please,
no, 1 minute. This is not a finding.
This is the order he has passed.
No, this is.
I cannot develop it now. This is the order has been passed, but the fact remains for consideration of your lordship.
No. See, whatever the case law may be, you can't say this is binding on a member board of revenue.
Exactly. Then
the member board of revenue, please, Mr. This order, my humble submission before your lordship, the member board of revenue is not the proper authority to
Which
seek
is
over
why he's
this order.
saying, sir. So let us give some benefits to the member board of revenue. What is he saying?
Yes, ma'am.
He's saying we are not clear whether Mr. Singhdeo is the adopted son or not.
Yes, ma'am.
All he's saying is let the civil court decide that.
Let the civil court
What you
decide.
are telling us is member board of revenue has no jurisdiction to even question this.
Yes, ma'am.
No, you can't.
I am saying that. No, your lordship.
If there is a convincing finding by the consolidation authority, yes, Mr. Singhdeo is the adopted son. What you say may be right because of the case law, which you are yet to produce. No, but I'm assuming that the case law says that you can never question the consolidation officer's finding. But there is no finding.
Here is no
the consolidation officer here has not given a finding, sir.
Even the consolidation, I am approaching to your lordship's query in another angle, my lord. Your lordship can see section 38B of the OE Act. Section 38B of the OE Act.
Yes.
It is a provision, and the so much power has been given to the member board of revenue.
Yes.
To examine the correctness of the settlement.
Correct.
Made under the Act.
Correct.
38B, your lordship, I am just for a minute I am placing before your lordship. 38B, revision.
Yes.
The Board of Revenue may on its own motion or on a report from the collector call for and examine the record of any proceeding in which any authority subordinate to the Board of Revenue has made any decision or passed an order under this Act. I am giving emphasis to this portion of that provision. This Act, not being a decision against which an appeal has been preferred to the High Court or the District Judge under Section 22 for the purpose of satisfying itself as to the regularity of such proceeding or the correctness legality or propriety of such decision or order, and if any case it appears to the Board of Revenue that any such decision or order ought to be modified, annulled, reversed, or remitted, it may pass order accordingly. I am just subject to your lordship's acceptance. I am saying that the order which was passed by the on which basis that Navin Chandra Singh has paid the rent, that order is an order under the executive instruction. That order is not an order under the Act, either under Section 6, either under 7, or Section 8A application.
Under what Act is he paying rent at all then?
2364
paying rent. You say Navin Chandra Dev is now thereafter paying rent to the state. This is what you've made.
State.
So that all happens under the OEA Act.
OEA.
Not under the OEA Act. Not under the OEA Act. That is my submission. Your lordship kindly see that division bench judgment below. That is my submission. It is not under the OEA Act. Subject to your acceptance. It is not under the OE Act. It is an order, recognition of tenancy.
No, sir. Just go back
Your
to page
lordship, can you see
107.
that order?
No, first paragraph of 107. 107 is where the impugned order of the member Board of Revenue starts.
Yes,
read that first paragraph.
No, you're... Yes, I am saying. Yes, ma'am.
Read that, sir. Read that. This revision petition.
The nomenclature may be OEA case. Nomenclature may be OEA case.
No, please.
Nomenclature will not decide. Your lordship kindly distinguish that division bench decision.
Okay, who started that? No, 1 minute,
63.
sir.
Volume 63.
No, let us go to the cross title of that OEA case.
The assistant consultation officer, additional tahsildar. Additional tahsildar. He is also exercising the power of additional tahsildar.
1 minute, sir. 1 minute. Where is that order? Which page is that order? 22.
Where the order is at in the counter of my learned friend. Counter of my learned friend at page 130. Running page 130.
Page 12 to 18. Counter.
Running page.
That is available at annexure B by 5.
B by 5. B by 5, 2185 order. 2185 order.
So this was a suo motu proceeding.
Yes, ma'am. The case is put up today. Objector of the case is present. The files a petition.
No. This case has been filed. 1 minute, sir. It's very interesting.
Filed by Mr. UC Das.
No. Case has been filed by Sri Navin Kumar Singh Dev, sir.
Yes, Navin Kumar Singh Dev has filed that case.
He has filed a case saying OEA case.
Not under the OEA Act. 81 million. 81 million. And your lordship, can you see that?
No. He has filed it under 81, sir. For fixation of settlement. He has invoked the OEA Act. He has gone before the collector.
OEA collector
was gone.
No, your lordship is right now. He has filed application. He has filed application before the OEA collector. But the division bench of this honorable court has said.
So now the argument is getting a bit desperate.
Yes.
Your vendor went under the OEA Act. He went before the collector, sir. He said, you better fix rent.
Accept the rent.
Whatever. But he went under the OEA Act. So therefore, the order was passed under the OEA Act.
The determining factor is under which provision the collector has exercised the jurisdiction. That is the determining factor as decided by the honorable division bench.
7 and 81. Come back to that page 132. That's your answer.
Yes, ma'am.
Navin has gone before the collector for fixation of settlement.
Yes, ma'am.
Under sections 6.
Under 6 and 7.
And 8(1) of the OEA Act.
8(1) of the OEA Act. 6 and 7, he is not an intermediary. That is not applicable. 6 and 7 is not applicable.
Sir. Now, I think
your lordship, I am not able to convince your lordship.
No. We are now discussing facts.
Yes.
This question of your vendor went under the OEA Act.
Yes.
He said, better settle this thing under the OEA Act in my favor. I am the adopted son. Correct? That's what he said.
Son of the adopted
I will not.
Son
I
of
will-
the adopted son. Sorry,
Milord,
sorry.
I will-
Son of the adopted son.
Milord, I will not give answer to this. Milord, my answer is 63, volume 63, 1987 CLT. Volume 63, the division bench judgment of the 1963 CLT. Milord, I will not repeat any more. It is subject to your lordship's acceptance. Your lordship kindly see.
Sheikh Kaur, sir.
When the salami has been fixed, 3 years rent as a salami has been fixed, the paragraph 6, your lordship kindly see.
All right. So we'll reserve orders, sir.
Yes.
That Justice, you said Justice
Yes,
Sakshi
I will
Patnaik,
give that.
That
I
you
will
can
give
hand
that.
over.
That
Yes,
judgment
ma'am,
I
I will
will
give that.
only take. That is a judgment that while deciding the right title interest, Justice R.C. Patnaik,
Yes.
the consultation authority incidentally can decide the plea of adoption.
Right.
But for that purpose, evidence has to be
decide.
adduced.
Yeah.
Issue has to be. It is not like a civil court.
Correct,
Not
correct.
that.
Yes,
And you have
actually
not.
decide
There is
that
no
issue.
finding.
Correct.
There is no finding
Milord,
here.
I am just placing
And
that
you
paragraph
yourself
6.
has
Milord.
filed the case.
Your lordship kindly see, I am just placing paragraph 6.
Also he never produced. Yes. Yes.
Coming to the order of the Board of Revenue, dated 12/10/1982, it appears that the member of Board of Revenue had exercised his jurisdiction under section 38B of the Orissa State Abolition Act. But as we have stated earlier, the order of the Tahsildar was under the lease principle and not under the provisions of the Orissa State Abolition Act. Therefore, section 38B of the Orissa State Abolition Act cannot have any applications since the settlement in question was not under the provisions of the said act. In this view of the matter, we are of the opinion that the Board of Revenue had no jurisdiction to exercise its power under section 38B. Why their lordships have hold that? Because the Board of Revenue, the order of settlement has fixed 3 years rent as a salami. That 3 years rent as a salami only can be fixed on the executive instruction, not under the act. Act has not contemplated any imposition of salami.
Your vendor has himself gone under the act.
Yes. That is annexed B.
Here is also a case where the application was made under section 6 and 7.
He himself was the applicant. Now he says that is without jurisdiction.
Mr. Mahanti, please wait. Let me complete.
You have already said.
That case is a case where the application was made under section 6 and 7, read with section 8(1).
We'll examine it. We'll examine it. Orders reserved.
Yes.
All right. Thank you. We'll come back.
Thanks to your lordship giving me present hearing.
Very interesting questions of law, sir.
Yes.
Very.
I will give that judgment.
That is there.
Excuse me, my lord. Item number 9 of today's list, my lord.
Into the mic, sir. Into the mic.
Item number 9. Item number 9 of the today's list, my lord. That is the case that it is an appealable order before the tribunal, my lord. He has not approached the tribunal, approached this honorable court, my lord. The liberty to approach the tribunal. That is my only thing.
All right. Mr. Patnaik seeks leave to withdraw this petition with liberty to approach the tribunal in appeal. In accordance with law, if such appeal is filed not later than 20th June 2022, accompanied with an application for condition of delay, it will be considered on its merits. The court clarifies it has not expressed any view in the matter. Was there a stay order here?
No stay.
No stay. Originals to be returned. Nothing, no original.
Yes, original first appeal order.
First appeal order.
The original be returned subject to being substituted when attested.
Tribunal decided on merit. Give direction of old case. The time
that obviously, sir.
Time may
be open to the
within 1
petitioner
year.
to request the appellate authority to dispose of the appeal as expeditious as possible. All right.
that I may be excused. Only one point I have left out to place before your lordship. That I have given that judgment now. That both the judgments of the Honorable Justice R.C. Patnaik and Honorable Justice S.C. Mahapatra. At paragraph 6, towards the last, their lordships have held. We are therefore of the view that the statement of law that the consultation authorities have no jurisdiction to decide the question of adoption, that being a question of status, is not correct. In almost every case, consultation authorities are deciding the question of status. But a declaration of law to that effect that the consultation authorities have no jurisdiction to decide the question of adoption, if such question arise ancillary or incidentally for the application of the right.
Right.
Now that is another point I have left out before your lordship. I have given that 96 Supreme Court. My submission before your lordship, even the consultation authority has passed that order, and that is a nullity. Even your lordship will hold that that is a nullity. Still, it is binding between the parties, unless and until it is reversed by the court having the competent jurisdiction. Certainly, Board of Revenue is not the competent court to examine the correctness of the order passed by the consultation.
All right.
And that is.
That was fixed for 2 p.m. hearing. Weekly list item number 17, WPC 10779 of 2020.
I'm filing an additional affidavit, my lord. Lordship may kindly take it on.
I am also filing some intervention.
Lords, I have also filed counter in Vedanta case, my lords.
Yeah, Mr. Giri, you're appearing here in
Lord,
this.
I appear in writ petition number 10930 of 2022.
Oh,
it's a fresh matter, my lord. The grounds of challenge could be similar.
All right.
Lord, what I have, my lord, submitted in the writ petition is that the contracted quantity, which they are not able to keep up, the rail
Your
linkage
lordships, this is in terms of your lordship's order as to how it has worked out. The affidavit.
Yeah, we'll take the affidavit. Yes, Mr. Giri. Just
My lords, the 70% of the allocated quantity, my lord, would be by rail linkage and 30% by road.
Oh. Okay.
Roughly. Now, my lord, there is a backlog of about 6.8.
So, Mr. Giri, today's news says that they're withdrawing a lot of passenger trains, increasing the rakes, only to carry coal.
My lord, but then it should be translated into a rail linkage insofar as, my lords, the industries are concerned. My lord, my problem is this: I have a smelter unit. My lord, if I'm called upon, if I'm compelled to shut it down for more than 6 hours, my lord, then resuming operations will not only be a very expensive affair, but then, my lord, it will take a lot of time. I have put it on affidavit, my lord, that might cost me about 380 crores every time if I am compelled to. It's a continuous process. Every smelter, as your lordships very well know, it's a continuous process.
No, we were told, in fact, NALCO also, we interfered only because of this very same problem. We were told that they have a smelter unit.
Vedanta's writ petition is also there, my lord. Vedanta's writ petition.
Correct.
My lord, there could be, your lordships are right, my lord, if there is a crisis, obviously, so everybody will have to chip in and then see that, my lord, that the crisis is resolved.
Correct.
But, my lord, maybe the contract, we have asked for the contracted quantity, but even if that is not available, there must be something called a trigger quantity.
No, so Mr. Giri, I had in fact put it to Mr. Dhruv Mehta also the other day.
Yes, my lord.
See, NALCO is a PSU, and there was some justification for us to interfere in 226.
Yes.
But in a PIL.
Yes, my lord.
But in both your cases, that is Mr. Mehta's and your case.
Yes, my lord.
Both of you are private sector enterprises.
Yes.
So I don't know if the same parameters can work in terms of PIL. So I might relegate you to a single judge or another division bench or whatever, because our jurisdiction here is a PIL jurisdiction.
Lord,
we only kept this all along. Yeah, we kept this along because, frankly, we were hoping that some solution will be worked out at the central government level, because it's a crisis facing the whole country.
We would most respectfully submit that your lordships may continue to retain it before your lordships bench, because if some order is passed in NALCO, it obviously would have ramifications, my lord, in the other matters which have reached your lordships. Anyway, my lord, it's a Chief Justice's court, and therefore, my lord, sequence,
Ultimately, my lord, Vedanta's smelter is the largest, my lord, in India and the second largest in the world, my lord. Your lordship knows this. public interest in the sense, my lord, there are 40,000 direct and indirect employees.
No, that is true. That is true.
And my lord, also, my lord, we pay a huge amount, my lord, to the tune of 40,000 crores, my lord, as taxes to the central and the state government.
No, Mr. Mehta, in fact, your petition was anticipated by two other petitions, which are one is represented by Mr. Surya Prasad Mishra,
Yes,
who's with you on the screen.
Yes, my lord.
And the other thing, Mr. Nanda was here.
Mr. Nanda was there.
Mr. Nanda.
So a lot of, my lord, downstream industries are also impacted, my lord. Downstream industries would also be impacted, my lord. So it has a ripple effect in that sense, my lord, a cascading effect. And therefore, my lord, there is in a sense public interest involved. I would respectfully submit and urge your lordships, my lord, to take up the matter, my lord. And since your lordship is already in season of the matter in Nalco's case, my lord, I would request if your lordship could also consider, my lord, granting a somewhat similar dispensation, my lord. If your lordships have seen the affidavit which I have filed today, my lord, I filed an affidavit, my lord, where I've given the necessary facts and figures, my lord.
No, but both to you and Mr. Giri, the only thing is, we can only ask that again they sit together to decide your cases as well. See, ultimately, several ministries have to come together, because this is also about allocation of resources, whether the railways or the coal ministry or mines, secretary mines. I think this is about allocation.
But it seems that your lordships had broadly indicated that if it's a private concern, why don't they import and then import coal as such? My lord, the import also, the problem, my lord, is that in the allocation which has been in the logistics plan, which they have said, there's nothing which is allowed, nothing which is made available or proposed to be made available, my lord, insofar as imported coal is concerned also to our sector. Everything goes to the power sector, my lord. Nobody denigrates, nobody, my lord, is trying to undermine, my lords, the importance of the power sector, my lord, being protected to a great extent. If they require coal, they require coal, my lord.
Right.
There's nothing, and after all, my lord, we also run on power.
That's
but the only problem is, my lord, there is something called, if not the contracted quantity, something called the trigger quantity, which means, my lord, the bare minimum that is essential to see that the plant keeps running. My lord, the loss that we suffer because the working of the panel or the production comes down is one aspect of it. That may not be a matter, my lord, which should engage your lordship's attention at this stage. But what is required to see that the smelter doesn't stop or the smelter is not shut down, my lord, because it's a huge, my lord, process by which we'll be required to start it again. And that's a very...
From your end, what have you done? You've sent in representations?
We have sent in a representation, my lord. The representation has also been placed on record. My lord, we have said that whatever is possible, my lord, should be done. Not that, my lord, we are insensitive, my lord, to what is going on in the country. Obviously, we cannot be. But then, my lord, some nudging from your lordships to the authorities might resolve the problem. Insofar as I am concerned, it's coming up for the first time before your lordships. But as my learned friend, Mr. Mehta, has been submitting, after all, probably the problem that we face is similar. My lord, maybe the quantity would be different, the trigger quantity would be different. But, my lords, if they can look into it, and then, my lord,
I wanted to point out something.
In the event of your lordships taking it up either tomorrow or the day after, if they get instructions, we would be deeply obliged.
But I believe MCL has filed, my lord, an affidavit just now and served on, my lord, local council, my lord, on our behalf. I have not had the opportunity to look at it, but, my lord, I just wanted to point it out, my lord. On the one hand, my lord, there is a grievance about, my lord, shortage of coal. That's the bottom line, my lord, which they are arguing. But on the other hand, I find, my lord, they're actually, my lord, MCL and Coal India making spot auction sales, my lord. Now, the two can't stand together. If there is inadequacy or shortage of coal, then there can't be spot auction of coal, my lord. I find that a little difficult to understand, my lord. So, my lord, I respectfully submit, if, my lord, as an ad hoc measure, till your lordship, my lord, issues, my lord, kind of a reconciliation or some kind of meeting between the ministries, my lord, some kind of ad hoc arrangement, my lord, just as your lordship had indicated in the NALCO matter, my lord, because as opposed to 12 rakes a day, I'm getting, my lord, 2 rakes a day. I mean, this is 15%, my lord, 15%. And, my lord, insofar as the road aspect is from the road also, my lord, there's shortage in that aspect. So out of my total contracted quantity of 62,000 metric tons a day, what I'm getting is 25%, my lord, both by roll and rail as well as by road, my lord. So it's 1/4 of my contracted quantity. So, my lord, the prejudice is immense, my lord. And ultimately, my lord, it's a huge industry in Orissa, my lord. And a lot of people, my lord, depend on this particular industry. Vedanta,
We'll just ask Mr. Pari what the instructions are.
My lord, because the new issues are coming, we don't have any instruction. But Lordship may see the minutes. In that
but Mr. Padi, you already have representations from both these companies.
I'm just a minute. I'm clarifying, my lord. Earlier, this minutes has been prepared by the ministry. What Lordship, I have direction of the Honorable Court.
Right.
All the secretaries sit along with the chairman railway board as well as the MD ALCO and MCL, my lord.
Right.
In that case, they have made an arrangement according to the FSA provisions, my lord.
Correct.
As regard to the open e-auction is concerned or who is importing the coal, there is no bar at all. They can go with this. As
No.
the present situation is concerned, my lord, they are checking.
Mr. Pari, let's try and understand this. Okay, this is not like there are some shops there. We can just go out in the market and buy. Yes. Importing means a whole process. See, you are disrupting an existing arrangement on depending on which they have the smelter plants, right? And these are smelter plants which can't shut down.
Well, government
if you tell them, no, Mr. Pari, I'm just giving you no, Mr. Pari, just a minute.
Yes, ma'am. Sorry.
One way to say it is, let's say from 1st July onwards, or let's say 1st June onwards, you tell them, give them 10 days advance notice, 15 days, or even a month's notice to say that from 1st June onwards, please make your own arrangements to import. Then they know what to do. It can't be that suddenly it drops down to 15% of their contracted demand. They don't have the trigger quantities and you're suddenly telling them now import it. They can't suddenly, overnight you can't import. It's not even doable. And importing means what? It has to come from a ship from somewhere in Australia. It's not like it will reach here in 10 days.
Sorry to interrupt, my lord, there's another problem, my lord. We can't blend, my lord. We can't use imported coal more than 10%, my lord, because our plants are not geared up for imported coal.
That's what.
That's a very serious matter, my lord.
So, Mr. Pari, first you have to tell us, what are you doing with their representations? Are you responding? Are you examining them? Are you responding to them?
My lord, I have received two copies, two different from Vedanta and this small scale industries.
No. I think Hindalco's is not given to Mr. Pari?
Hindalco,
we have, sir.
I didn't have the copy, yes.
We have, sir.
Let them sub the copy. Let's keep it to next week.
Not week. No, not week. It will have to be day after or maximum Friday. Day after or Friday.
My lord, let's keep it to the next Monday because today is Monday.
Let's be clear, because if they don't have the trigger quantities, they shouldn't come to a point where they have to shut down a smelter plant. This is not such an ordinary shutting down, Mr. Pari.
Yes, I understand.
It will take several months, and I was told in Nalcos it's 2 years it would have taken.
My Nalco's case is different because Nalco is completely based on the coal-based unit. Here the other companies are there. They have some alternative.
Which companies? Which companies?
Completely good.
Putting up Nalco and putting up others cannot be compared with each other, my lord. My lord, may I pray, my lord? May I pray? It may be taken up on next Monday on 9th. And in the meanwhile, after instruction, as well as I also advise them what.
Mr. Pari, Mr. Pari, on two things you have to get back, and most probably day after tomorrow.
Right.
While we may have a holiday tomorrow, I know bureaucrats, whether it's the state government or central government, there's no holiday for them.
Let's say 5th.
Sorry?
Thursday, 5th.
So on 5th, you tell us whether you can fix dates for hearing them. Okay. In you have a panel of secretaries or joint secretaries or whatever. Let that be the power secretary, the railway board representative, and mines secretary. Let that be a panel, and let them hear these two companies.
My lord,
the representative of these two companies will come and make their presentations.
Yes, now.
Yeah, just give them some time, hear them out. Then whatever you decide, you decide. We're not going to dictate to you.
Yes,
but just hear them out.
That part I'm not. I know this legislation. This want to try to solve our problem. I very well conscious in this regard. But what I'm praying, my lord, unless until it has no, I'm not getting any instruction or I will not ventilate the same, they may not acted upon. That's why I'm praying some time. Otherwise, we don't have.
No. For hearing them, I think so. Day after you tell us on what date you will hear them.
On 5th, I will appraise, my lord. On 5th, I will definitely appraise, my lord.
All right. 3 to 5 years. You put down both. You say
my lord, some interim arrangement. I was.
My lord, no, my lord. In that, my lord, Lordship may not pass on. I request all of my senior friends. They instruct any of the associate council. They can serve the extra copy of the same or any copy I have didn't receive. Then I will immediately I can make it correct.
Would your lordship consider some interim dispensation, my lord? Some interim.
No, between today and day after, let's not because if they're hearing you, they might as well find a solution. There's no need for an interim thing then. You say put down 10779 of 2022 and 10930 of 2022, along with the two other district industries.
10422 and 10423.
Correct.
10423 and 10424, my lord.
Right. You say writ petition 10779 of 2022 is by Vedanta Limited, and writ petition civil at 104. 10424 are
10424
connected with this writ petition as it concerns the impending crisis faced by Vedanta Limited on account of the precipitous drop in the supply of the contracted quantity of coal. Mr. Dhruv Mehta, the Senior Counsel for Vedanta Limited, points out that with the sharp drop in the supplies, there is a real and imminent threat to the smelter plant of Vedanta Limited at Jharsuguda.
Jharsuguda, my lord.
At Jharsuguda having to shut down. In which case, there will be a cascading effect.
Jharsuguda and Lanjigarh.
And Lanjigarh. In which case, there will be a cascading effect on all the ancillary industries, including the MSME units and a huge workforce involved in all these units. Paragraph 10930 of 2022 is by Hindalco Industries Limited, voicing a similar grievance in connection with its smelter plant. You say 10930 is by Hindalco Industries Limited as well as Utkal Alumina International Limited, voicing a similar grievance in regard to the smelter plants at Mr. Giri. Where are the smelter plants?
Unmute yourself.
Lord, the smelter plants are at Lapanga and Raigada.
Raigada and
Lapanga.
Lafanga.
And Hirakud also.
Okay, and Hirakud. In both cases, you say, what is your representation date, Mr. Dhruv Mehta?
20.
I'm sorry, my lord.
Your representation?
My lord, my representations, my lord, there are several of them. They're page 415 onwards, my lord, I have given.
Give us the last of the ones.
Yes, my lord, 414.
Give us the date. Give us
21/4/2022.
Lord, 12th April 2022.
All right. Vedanta's representation stated.
I'm sorry. Just 1 second.
21/4. 21/4/22, Annexure 9.
Okay, Lord. Dated 21st April 2022 and Hindalco's.
Lord, dated 25/4/2022.
Yeah.
At page 113.
And Hindalco's representation dated 25/4/2022 are stated to be pending with the central government.
My lord, I'm sorry to correct, my lord, it's 28th March 22, my lord. I'm so sorry.
No, in my case, it is 21/4. And yes, in our case also 21/4.
All right. And the representations dated 21/4/2022 of the petitioners in 10423 and 10424 of 2022 are stated to be pending with the central government. Paragraph. the court is entertaining these petitions and essentially on the for the reason that it involves not just the industries themselves, but the prospect of affecting the livelihoods of lakhs of workers and thousands of ancillary units. Stop. While in the entire country there is a crisis being faced by the power industry on account of the drop in coal supplies, there will be a need to balance the competing demands, which are all in public interest. And this can best be achieved by having the central government constitute panels of bureaucrats representing the different interest groups who can give a hearing to the petitioners and address their concerns to find workable solutions. Full stop. The court can at best be the facilitating body for arriving at such solutions. Paragraph accordingly, it is directed as under 1. On the next date of hearing, the central government, which will include the Ministry of Coal, the Ministry of Mines, the Railway Board, the Ministry of Power. Speaking through Mr. P.K. Padi, Learned Additional Solicitor General of India, Assistant Solicitor General of India, will inform the court the date on which it can, the date or dates on which the 4 petitioners, that is the Vedanta Limited, the Utkal Chamber of Commerce and Industry Limited, the District Small Scale Industries Association, and Hindalco Industries Limited, and Utkal Alumina International Limited, each of them through their authorized representatives can be heard by the central government of a panel constituting the aforementioned ministries and labor board to the interim arrangement that can be made till such hearing is completed and a decision and a workable solution found to address the issue. For the above limited purpose, Mr. Pari says that he can get back with instructions on Thursday, 4th May.
5th May, my lord.
Thursday, 5th May, sorry. Thursday, 5th May, 2022. So list on Thursday, 5th May, 2022 at 2 p.m. All right.
Lord, I have a request, my lord. Respondents 3 to 5 are Coal India Limited and MCL.
Yes.
We have tried to serve copies on them. Probably, my lord, the council did not have instructions to receive. Can we serve it on the same council who's appearing in Mr. Mehta's matter?
Yes, Mr. Devraj Mohanty.
Yes.
Yeah. All right.
We'll do it.
All right.
May I pray one
And
thing?
serve the copy.
Yes.
May I pray, my lord? If I know the lordship's order is coming very fast. Till then, I request, my lord, if this copy will come in the priority basis.
Yes. Copies of this order be made available today itself. To the party.
My request is
Mr. Pari says that he will communicate it today itself to the concerned ministries and the railway board.
Yes, madam. Yes, madam. Well, let it concerned councils are appearing, they will give the list.
My request is, madam,
all right, but you yourself also do it, Mr. Pari. It has a different effect.
Yes, definitely.
Sorry?
Lord, I was only saying that central government should not take this as an adversarial litigation, my lord. We should all cooperate, my lord, and solve the issue.
No, I think they are not taking it, Mr. Mehta. To be fair to them, they're quite hands-on on this issue. Let's hear Mr. and Ms. Ratha.
Only thing is, my lord, stock is now getting exhausted. That's the problem.
I know. No, they will come back with dates.
Would your lordships, my lord, give us permission by Wednesday to put on affidavit, my lord, the facts and figures as to what is the stock that is available and how far we could run?
More importantly, that should go to the central government.
That apparently, my lord, has already been intimated to them, but let's see.
All right. You said to be open to both the petitioners to file additional affidavits in the meanwhile. All right.
Very good.
Your Lordships will kindly look
Grateful
at
to
that
your
affidavit. There's a table in that affidavit.
Yes.
Second page, Your Lordships will see. There's a table.
Yes.
Your Lordships, it gives us an idea about what has happened after 27th April.
Right.
Your Lordships will see that according to the MOM, through MGR method, you're supposed to give us 5,000 to 6,000. It's been quite good when it comes to the MGR. Every day, Your Lordships, the quantity has been quite good.
And it's
Your
improving. It's improving.
Yes, Your Lordships. As far as the road transport is concerned, that's really taken a setback as there are many issues there. And so therefore, we are falling short there. And as far as the wharf wall is concerned, it's also remained more or less the benchmark. There's been no supply as far as from the railways through railways are concerned. Your Lordships will look at that figure, last figure. We are in an average.
I think they're giving you only 2 rakes a day.
We are not getting any rakes.
No. They don't do the last.
Lordship, that's Damanjori. The figures that I'm mentioning is about the CPP NALCO.
Oh.
And the average comes to 10,327. The MOM said that we will be getting around from 11,000 to 14,000. So average is here. So we are, of course, falling short. And in the affidavit itself,
but you're surviving.
We're just surviving.
That's all.
I would not disagree on that because of because of the ministry and Your Lordship's indulgence. In the affidavit itself, Your Lordships, there's a small at page 5, para 5, Your Lordships. In the affidavit itself, yes, it's improved. I think 1 rake will really make the survival. If consistently, because the road and you know, so as far as Damanjodi is concerned, we are getting 1 rake, so which is like neck to neck. So one day if it stops, our refinery really stops. But they're giving. Why should we? They're giving. As far as the railway has been a little problem. So if that can just draw concern of all parties.
Let Mr. Pari come back with instructions.
Can I just supplement? What, just by way of supplementing what was argued on behalf of NALCO, Mallards, they have said in that meeting of secretaries, 58 to 60 rakes they have allotted to the Talcher coalfields area. So therefore, a request for allotment of one rake for CPP and 1 rake of the linkage coal, that is, we already have 89 crores of rupees lying with MCL. I don't think that would be...
no, the rake. Rake is actually the railways headache, right?
Yes, railways is there also before Your Lordship. Just allotment of 2 rakes. Out of 58 to 60 rakes, they are allotted to the entire area. That was agreed by the Secretary Center.
You're right.
So therefore, 2 rakes for NALCO balance will not harm anybody. And it will
let him take instructions. Let him take instructions.
Let him take instructions on that.
So far as road mode is concerned, they have agreed to take 6,000 empty millers, but he has lifted more than that millers. It is millers in compliance of Your Lordship order. They have lifted millers 7,320 millers in average millers. 7607 30th April millers and 20th April is millers 7674 and 28th April is 7042, but agreed quantity is 6,000.
Which
More
one
than
are you
that,
talking?
we have supplied.
You are talking of combination of both
only road. I have made a chart, millers.
As on date, out of the agreed quantity of 14,000 as per the FSL and the Ministry of and the secretaries, combination of secretaries, we are falling short of 4,000 per day, and that is, my lords, the real figure, and that is there. So that figure is not my friend is not addressing that part, and he is rather getting in that they are lifting. Why is he trying to defend the railways?
No, I am not defending. If railway is placed the track, so I am ready.
These figures have not.
They
are not on affidavit also.
MCL's figures have not been supplied to us. Neither they are on affidavit.
We don't have any copy of those figures.
Giving any copies.
And neither that is on
We
affidavit.
have no way to know
I'll
what he
give
submitted.
affidavit, my lord, because
No,
just
you'll have
now
to make copies
You
and
have
give
to,
them, sir. How can you make only 2 copies?
Unless
I
that
have
is-
made a copy, my lord. Just now I have received my lord's.
and he passes on without an
not
affidavit
making in
on
my
that.
affidavit, my lord. I'll give a form of affidavit.
My lord,
I
I'm
think you make
appearing for
copies
the
and-
interveners, my lord.
Just give it to them. Give it to them.
I'll give it. I have a copy, my lord. So I'll give. So far as road is concerned, I am not defending rail, my lord.
April
Road is concerned,
26.
they have taken more than that.
They've taken the whole month's aggregate. They've taken the whole month's aggregate.
Whole months.
No, 26, 27, 28, 29, 30. I have taken.
4 days.
This is not matching at all, your figures.
Our figures will come. We have a SAP record. Our figures will show. I mean, we can't do anything. This is not on affidavit also, Your Lordships. We'll not be able to
I'll
answer that also.
To that extent, my lord.
Unless it's not an
Because I-
affidavit, I'll not be able to
My lord, I have
reply.
just received that. That's why
Anyway, I don't know. This is
I'm
not
fi-
adversarial, sir. So let's not
Yes.
get into this.
My lord, I'll file in form of affidavit.
All right.
I had a small request, my lord. My friend should not stand in the way. I was only requesting your lordship that 2 rakes and needs to
That's what
take instruction.
we'll note it down. You see,
Mal,
in
that is-
Nalco-
It's arrangement with the rate.
My lord, I'm appearing for the interveners, my lord. I'm filing another 7 interventions.
Sir, please, we'll have to stop this now. See, it is not adding to, it's only adding more and more paper to our court.
No, my lord.
Is there anything, sir, just honestly you tell me, is there anything in any of the orders that we passed that day and we passed so far that you are finding objectionable?
No, my lord.
Are you anyway helping?
No.
What I'm saying is your intervention going to dramatically change
No,
what
my lord.
orders
No,
you are
my lord.
passing?
No, I bow down. I bow down.
Don't just keep filing stuff for the
My
sake of
lord, I will
filing.
not file them. My
Just
lord, can
keep
I
it
make
back.
one submission, my lord? One very valid submission, my lord. This is, my lord, the whole new coal distribution policy of 2007, my lord. My lord, have a glance at it. They are making my lord, a discrimination on basis of power and non-power sector.
Sir, this is not the time to argue this policy, sir. We are in a real crisis in the country.
Okay. My lord,
All this policy will not work, sir. This is for ideal times when there is no problem at all anywhere in the country. Then we can look at all this policy, not in this kind of a crisis.
My lord,
This is the wrong time to do this.
Crisis in power supply.
No power.
In the entire country.
You say in the Nalco matter, this is WP civil number 10260 of 2022. Affidavits have been filed both by the Nalco Officers Association as well as Nalco, placing in record certain figures regarding the supply of coal after the orders passed by this court on as per the minutes of meeting of 27th and as per the minutes of the meeting of 27th April 2022. It is stated that the range of coal supply from FSA is working out to barely around the average of 11 to 12,000 MT. Full stop. The request by Nalco is that if one rake is provided by the railways to supply to the CPP at Angul and one more rake for the SPP at Damanjodi, then it will improve the position of coal supply and ensure consistency. Mr. P.K. Padil at ASGI will obtain instructions on this request and inform the court of the stand of the railway board on this issue on the next stage. Then you see Mr. Devraj Monti, learned counsel for the MCL, states that he will place by the next date an affidavit on record indicating the actual quantities of coal supply made by MCL to Nalco since the orders passed by this court.
One last submission, if you lordship permit me, on behalf of Vedanta, my lord. I just had, my lord, the privilege of looking at the MCL affidavit, my lord. They are saying that the problem is non-availability of rakes. If that is a problem, my lord, and if they are willing to supply, I can even bring it by road, my lord.
All right, let them indicate. Let them indicate. All right.
Lord, MCL council is there, my lord. They just hand over.
I have also released the millers. I have also supply order already been released millers. That is millers. Which mode he should take up?
No, he wants to take it by road. He says.
Yes, I will take it by road.
We have agreed.
He has no problem. He says
by road.
Yes, I will take it by road.
So let them.
Tigger level quantity millers, I have releasing millers, 75% of the contracted quantity millers. And they also prefer which mode they have to take, leave the coals millers. Because
he's right now saying
because it is responsibility of the millers, responsibility of the petitioner to choose the modes millers.
He's saying he wants to take it by road.
My lord, may I clarify one thing, my lord?
Yes.
Yes, minutes. It was very much clarified that the railway is ready to give the 50 to 60 rakes per day.
That's right. How they're distributing the rakes, we don't know, sir. So come back with instruction.
That distribution.
So it is better to get an instruction and accordingly, let's make contact.
No, that's what we've said that. On 5th, come back with instructions on 5th.
My lord, this NALCO matter will be fixing on 5th?
5th, same thing, sir. 5th at 2 p.m.
My lords.
Lord, if your lordships give my lord MCL the liberty to consider this aspect at least, my lord, that if I'm willing to take it by road, there should not be any impediment, my lord. That's all.
All right, Mr. Mounty, you can put it down on affidavit if you have no problem giving it to them for transportation by road.
On 5th.
All right.
All right.
Okay, sir. All right.
Great.
Right.
Special weekly list pastor matter item number 38.
I was just placing that an order under Annex 7 passed by the.
That is a downloaded copy, my lord. It is reported in OLR 2016 volume 1 209.
I have
also CLT, also AR, also it is reported.
I have 2 copies from AIF reported in AR.
Compilation.
Before going to the reported judgment, Lord Siddhamaka judgment, I may just place the facts of the present case, thereafter I will come to that. Here, in fact, kindly have a glance. Of course, these documents are in ODL, you may kindly have a glance. Under Annexure 1 at page 10A of the brief, the property was recorded in the name of Lord Jagannath, represented by a moth. There is a reference to Amrit Manohi also there. That will cause the problem. Thereafter, this property at one point of time was leased out in favor of the present opposite part number 3, one Gosala, by way of a registered deed of lease, that is Annexure 2. There is no dispute to these factual aspects at this point of time. Then Annexure 3 is a document that is obtained under the Right to Information Act, where the property, that was the stage when this subsequent settlement operation started. The property was kindly have a glance at Annexure page 22. The property was directed to be recorded in name of the lessee, that is Gosala, pursuant to the lease granted by the ex-intermediary. After this direction, the record of right, that is of the year 1980, was also published under Annexure 4, page 23. That was in the name of the Gosala, the lessee. That continued, and payment of rent was also accepted by the government. Suddenly, a claim case was filed. That is under Annex 7. Kindly have a glance at page 40. This claim case was initiated in the year 1990 by the administrator Sri Jagannath Temple. I am challenging the very initiation of this proceeding because the initiation of this proceeding is bad in the eye of law, what I beg to submit. In this proceeding, the property was directed to be recorded in the name of the Sri Jagannath Temple. Thereafter, it was challenged in appeal, it was confirmed, then in revision also it has been confirmed. So the present writ petition has been filed. Now, if you also can have a glance at page 40 and 41, the order of the Learned Tahsildar Puri. At page 41, the Learned Tahsildar, that is at paragraph 4. I am just tracing what is the claim before the Learned Tahsildar. In course of trial, the AA of the administrator explained that those properties belong to Lord Jagannath. In support of their claim, he submitted that the copies of various circulars and Sri Jagannath Temple Act gone through those documents. The claim of the Marfatdars, that is Secretary Jagannath Gosala, is not taken into consideration and he has not filed the same in stipulated period. Lords, this claim case was filed by the temple administration, not by Gosala. A presumption is being taken by the Learned Tahsildar as if the claim has been lodged by the Gosala, therefore he has not substantiated the claim. Even then also these documents, the earlier documents and the registered list, those were also produced. But without recognizing those documents, without taking into consideration those documents, next para I am placing, peruse the copy of the letter issued by the administrator Sri Jagannath Temple Puri, dated 31/12/92.
Page number?
It is ascertained that the land
Page number.
Page number. Sorry,
Next
sorry.
page, 42.
Next page 42. Rounding page 42.
Yes.
42, paragraph 5. Peruse the certified copy of the letter issued by the administrator Sri Jagannath Temple Puri, dated 31/12/92. It is ascertained that the lands recorded in the name of Sri Jagannath Mahaprabhu, Vijay Puri, Amrit Manai Marfat Swanso, under Stitiban royalty status are essentially endowed lands of Lord Jagannath Vijay Puri. Here, in fact, the confusion started merely because there was a term Amrit Manahi.
Yes.
The Learned Tahsildar has taken the entire property to be the property of Lord Jagannath. That is under challenge, and ultimately it has been here the case of the earlier judgment of Siddhamata comes into picture. Now the claim is that under this judgment, all the Amrit Mahane properties have been treated to be the properties of Lord Jagannath, which I may place that Amrit, the Siddhamata judgment, which before our worship's board, that in fact accepts the earlier constitution bench judgment of the 1967 and makes a distinction between the two categories of Amrit Mahane properties. One Amrit Mahane property belonging to the temple administration directly, and the second one is the Amrit Mahane property managed by the mutts. May I just place that part of the judgment? Let me kindly have a glance, because here two questions were raised for consideration. Let me kindly have a glance at page 568 of the reported judgment. 568. What are the questions before the Honorable Apex Court? 568, the second column.
Whether the suit lands can vest.
Pardon?
Whether the suit lands can vest in the respondent mutt. Question number 1, sir.
Yes.
Whether the suit lands can vest in the respondent mutt
in the light of the provision of our Sri Jagannath Temple Act. and then whether even otherwise the mutt had the right to prefer claim rights in respect of the temple lands and initiate proceedings under the OA Act 51 by virtue of being an intermediary. So these two were the questions. Incidentally, the question arose whether the Amrit Mohani properties, what is the nature of the Amrit Mohani properties and what can vest in the temple administration. Kindly now have a glance at page number 571. I'm just placing now that paragraph, second column, paragraph 10. Mr. M.L. Verma, the learned senior counsel, appearing on behalf of the respondent, mutt contends that the controversy in the instant case is squarely covered by two judgments of this court: the division bench judgment in the case of Lord Jagannath, AR 1989, Supreme Court 464, and the constitution bench judgment in the case of Surjanarayan Das, referred to Supra. The learned senior counsel places strong reliance on the following paragraphs of the decision in the case of Surjanarayan Das, Supra. We may now consider the properties in Schedule Kha said to be the Amrit Mohani properties of Lord Jagannath and held by the plaintiff or Marpatdar. The plaintiff alleges that these properties were acquired either by purchase or kriyadan or by way of gift, subject to charge of some offering to Lord Jagannath, which depended upon the individual judgment and discretion of the plaintiff, and that the public had no concern with the enjoyment and management of the usufructs thereof. The gazetteer makes a reference to such properties and states both Saiva and Vaishnava mutts exist in Puri. The lands of the latter are known as Amrit Mohani, literally nectar food, because they were given with the intention that the proceeds thereof should be spent in offering Bhoga before Jagannath, and that Mahaprasad thus obtained should be distributed among pilgrims, beggars, and ascetics. They are distinct from the Amrit Mohani lands of temple itself, which are under the superintendence of Raja. Here makes the difference. The statement makes it clear that lands endowed to the temple of Lord Jagannath are distinct from the lands or property endowed to the Vaishnava mutts for the purpose of utilizing the proceeds of those properties for offering work before the Lord Jagannath and the subsequent distribution of Mahaprasad among the pilgrims, beggars, and ascetics, presumably visiting the mutt or approaching the authorities for a portion of the Mahaprasad. The mere fact that the proceeds of the properties were to be so used would not justify the conclusion that these properties were not endowed to the mutts, but were endowed to the temple of Lord Jagannath. Properties endowed to the temple of Lord Jagannath were, according to this testament in the gazetteer, not under the superintendence of any mutt or mahant, but under the superintendence of Raja of himself, Puri. As already stated, these Amrit Mohani properties are properties which are endowed to the mutt by the devotees for a particular service which is done to Lord Jagannath by the mahant on behalf of the mutt. These properties are therefore properties endowed to mutt and not merely gifted to the plaintiff or as has been suggested to Lord Jagannath. So after making this two distinctions, let's see now how it has been accepted by the judgment, the Siddhamata judgment. Also kindly have a glance at page 79. This was reiterated and accepted. There are no differences of opinion in this Siddhamata judgment at least. Page 79 and 80.
You mean 579?
579, sorry. 579 and 58. From 579, from the second column I'm placing. On the other hand, keeping in view the growing irregularities in the management of the affairs of the Temple Act 1955 was enacted by the state, which received the assent of the President Sanso. We agree with the contention advanced by the Sri Harin P. Rawal, the learned senior counsel appearing on behalf of the Appellant Temple Committee, that as far as the Jagannath Temple of Puri and its endowments are concerned, the provisions of the Temple Act of 1955, being the special law, take priority over the provisions of any other legislation. Section 5 of the Temple Act 1955 makes it clear that the properties and endowments of the temple thus statutorily vested in the Temple Committee. The Constitution bench judgment in the case of Surjanarayan Das, 1967 Supreme Court for 256, referred to Supra, draws a distinction between the Amrit Mohani properties of mutts and temple in the following terms. The Gazette makes again the same has been quoted.
Repetition.
May I place it?
No, you're repeating, sir. You can skip that.
Yes, I'm skipping that. There are page para 22. The OA Act 1951 then enacted. this then again went to the question as to whether the Section 5 of the Temple Act runs contrary to the amended provision of the OA Act. It was declared ultra-vires. The amending provision of Section 200 of the OA Act are declared ultra-vires. Now, this question as to whether the properties endowed to the mud as Amrut Mani was never disturbed, as it was distinguished in the earlier constitution-based judgment. So, because there are two nature of Amrut Mani properties, those properties which are Amrut Mani properties which are endowed to the temple directly can rest in the temple administration, but not those properties which are endowed with the mud. So, in the present case, there was absolutely no document, at least showing that at any point of time, the properties belong to Lord Jagannath represented by the temple committee or the Raja of Puri at any point of time. There is no document. Directly, the claim was filed in the year 1990. And this claim case of 1990 was stated to be filed under Section 6 and 7 of the OA Act. Kindly have a glance at the page 40 of the brief annexure 7.
Yes.
States this OA case was initiated basing upon the claims of the petition filed by the administrator Sri Jagannath Temple Puri on behalf of the Temple Management Committee for Temple Management Committee Puri for fixation of fair and equitable rent and settle the following land schedule in favor of the Lord Sri Jagannath Temple Vijay Puri, Marfat Sri Jagannath Temple Management Committee under Section 6 and 7 of the OA Act. What I beg to submit, Lord, is such an application under Section 6 and 7 of the OA Act in the year 90 was not maintainable because at no point of time the temple administration was recorded as the intermediary in respect to the property in question. That is why the initiation of the proceeding is illegal in the eye of law. Apart from that, there was absolutely no inquiry, no documents have been. It is the learned Tahsildar only refers to some letters and coming to a conclusion that the property has been vested. But there is absolutely no document to show and no inquiry in that regard to show that the property, in fact, the Lord Jagannath Temple represented by the administration was at in any point of time was the intermediary in respect of the property in question. So such a claim case was, initiation of the claim case was illegal in the eye of law. Now, even after rejection of the order, I prefer appeal under Annexure 8. The appellate order is also Annexure 8. That is at page 45. There also, kindly have a glance at page 51, turning page 51. There, the learned appellate court comes to a conclusion regarding the recording also. I carefully examined the matter by taking into consideration the arguments advanced by the learned advocates, documents and citations as filed by them in this case. Perusal of the lower court record, it is revealed that the suit plot number so stands recorded in the name of Jagannath Gosala Puri, Marfat Secretary Purushottam Sundar Das. Next page. In the middle of the page 52, there is also reference.
Your Mohan Lal Punch, who are you?
Oh, that is the purchaser. That purchaser from the ultimate lessee. That document I have annexed. Okay. I have annexed that. After the
purchase by what? Registered sale deed?
Registered sale.
You can buy all this by registered sale deeds.
Registered sale deeds. Registered sale deeds. Registered lease deed.
What is the system in Orissa? All these
petitioner.
Those are lispendants registered sale deeds. After the claim case was initiated in 1990, these petitioners, they acquired the property purportedly by virtue of Annexure 2 and 3. Those are two registered sale deeds of 1998, 8 years thereafter.
But the order came subsequent. Kindly have a-
Maybe.
Order in the
So
1999.
this Marfat Das can actually execute sale deeds.
That is the main.
No.
That cannot.
They cannot, my lord. It is also
Their
decided,
sale deed
my lord, in
itself is
the
unlawful.
if your lordship see
No,
the
but somebody is registering these sale deeds, no? These
That is what
officers or
happening.
whoever sub-registrar, I don't
That
know
is
where
what
the
happening
system
also.
sub-registrar here. No? So he will merrily simply register a sale deed when he says I'm Marfatdar of Lord Jagannath BJ Puri. The man will register.
And there is a status noting Amruta Manohi. Once his status noting is Amruta Manohi, it cannot be touched.
is the Amrutamani of Lord Jagannath, my lord. It's a proper.
And the sub-registrar will happily register a sale deed.
No, sale deed has not been executed by the Mutt. Mutt leased out the property in favor of a Gosala.
So this lease, this is the precise thing.
Yes.
One leasehold property can actually be sold.
My lord is asking the whosoever be the vendor, how it could
can
be
you
registered.
sell a leasehold property? What is the selling of a leasehold property, sir?
It's a
I've
permanent
never
lease.
understood this.
It's a permanent lease, and
You cannot sell, sir. What does sale mean?
Yes,
Absolute
transfer.
ownership, right?
Transfer. Yes, absolute transfer.
How can you? You don't have absolute title. What are you transferring? You only have a leasehold title.
And my learned friend would not disagree. The basic purpose of grant of lease was for Seva Puja of the DT and to
But
give
how
the
can all
usufructs
this be
to the.
sold, sir? We are using the word sale very liberally. And we are also registering sale deeds.
That is also.
Right, it is also, my lord, it is also discussed by the appellate authority, my lord. If your lordship see, my lord, page 53, page 53, page 9, internal page 9, middle portion, my lord, 2-3 lines there from the top, the recital, my lord. The recital of aforesaid registered lease deed number such and such reveals that the suit land belongs to Amrutamani of Sri Jagannath Mahaprabhu. So admittedly, this property is the Amrutamani of Lord Jagannath.
Right.
Under D register number such and such. This on perusal of the notification number such and such dated 14/9/63, it's revealed that the DR number, D register number, my lord, has been declared by the tribunal as toss estate under section 13E of the OEA Act. Therefore, it is held that the suit land has been vested to government in 1874, but not on 29/4/63. Further, it is held that the suit land belongs to Amrutamani of Lord Jagannath, my lord. So it's the property admittedly is the Amrutamani of Lord Jagannath, my lord. And as per the judgment of the Honorable Supreme Court, my lord, it said that Amrutamani property is all through is the property of Lord Jagannath, my lord. And if your lordship see one paragraph I am reading from the judgment.
No, let him finish. Let him finish. See, I just had a doubt. How can you have registered sale deeds? That's all.
Lord, in fact, the registered sale deed was executed by the lessee. Be that as it may,
How is it, sir? You're good
law, that is illegal.
1 minute. All of you are very good in civil law. I am not very good in civil law.
No, your lordship is.
No, I'm very poor.
Dealing with civil matters as if your lordship is expert in civil law.
A lessee can execute a sale deed in respect of the land.
Provided the lease provides that there is an alienable interest.
Only an interest can be alienated, sir.
Yes.
Even that lease, the interest of lease can be transferred.
No, that cannot. Lease is a particular purpose.
Without reference to the original lessor. Not at all, sir.
Not at all. Perhaps wrong.
My learned friend also knows the judgment of the Honorable Court where the Khasma leases have been decided to be absolute property.
This is for a particular religious purpose. I am giving one illustration to your lordship. If I have obtained the lease for a purpose of Seva Puja of this, tomorrow I will transfer the lease to a Mohammedan person.
For a hotel to be constructed.
Then the purpose of granting lease is frustrated.
Completely.
What I beg to submit is, there is no frustration of the purpose belief, even assuming for the sake of argument that the sale deed is illegal. But the lease remains.
So you're claiming under a sale deed.
Yes, I'm claiming.
But you go out of the picture. What happens, we'll decide later. On that lease, what happens, we'll decide later. If you are claiming under an illegal document, you have nowhere to stand.
The claim I am making is from the 1925 ROR. It is a subsequent.
So how it came to you is important. It came to you through a registered. You are saying till now you are calling it a registered sale deed.
Yes.
If that document itself is illegal in the eye of law, where's the question? You don't get any locus standi, any status, nothing. Then no need for Siddhamata or any other thing. All this judgment will not help.
If that is
a fact of the matter. How will the Siddha matter doesn't make any difference?
Because
if the sale deed itself is illegal.
The basic infrastructure of his claim is vitiated in law.
That's right.
These two sale deeds are unacceptable in the eye of law.
Correct.
Because it is for a particular purpose. They could not have alienated it. And now I don't know whether this land they are intending to use for other.
I keep telling all my brother judges, and he also knows, we will sit here and decide something on the ground, something else will be happening.
Yes. Because it is all Puri town land.
We don't know how many hands it's changed. He thinks he's representing a client. Something else must have happened. You filed it in 2011.
Now nothing has happened. It is barren land till today also.
All right. Fortunately, in some other cases, even the lawyer does not know what has happened to the land.
No, here I am conscious of the status of that. At present status also I am conscious.
All right. Good. At least to that extent.
May I read one paragraph from the judgment, my lord, for your lordship's convenience?
No, he's already in difficulty. Let him overcome the difficulty. Yes, Mr. Monty.
Yes. Only answer my to this is there is no embargo, at least in the lease deed, not to alienate the property.
So this whoever draws up these sale deeds, gets it registered, this is the whole problem, sir. We don't have anything.
Can I place the judgment of the Honorable Court in that case, lease case?
All right. Whatever.
No.
Maybe place day after tomorrow.
No.
I think Khasma lease is not equal to this type
of lease. It's a permanent lease.
No.
There, this Honorable Court has come to a conclusion that permanent leases are of nature of the permanent right. It can be sold even without sanction of the original leasing authority.
Yes.
That judgment I can place, my lord.
We're not adjourning, sir. Sorry. Not after this hearing so long. Anything else, sir?
No, so far as this your lordship's question is concerned, so my answer is it is transferable right because the permanent lease has been granted with a permanent right, and that I can place the judgment of this Honorable Court also a permanent right granted on the lease can be transferred.
You file a note along with the judgment. Yes.
And after this new act came into Temple Act came into force, all Amrutamanohi land vests to the Lord Jagannath. Once it is noted as Amrutamanohi land, nobody can claim right over that. That is the decision of Siddha Mata.
And my lord, section 5
is not distinguishable.
Section 5 and section 33 is very clear. That also taken care by the Honorable Supreme Court, my lord.
Right. All right. Orders reserved. Parties are permitted to file a written note of arguments within a week. All right. All right.
Weekly list, fresh admission, item number 1.
May I please? Should the present petitioner represent the entire population of ward number 3 of Ranalai ward, that is in Mahendragarh GP, And their
Engagement of
grievance is,
Anganwadi worker.
let's say the grievance is
So
one
this is all
public-
service matters, sir. There's no PIL in this.
Yes. Let's say
This is all service matters. Wrongful engagement of some Anganwadi worker is not a PIL. Sir. Let's say petition makes a grievance about alleged wrongful appointment of Anganwadi workers. These are matters within the realm of service law, and therefore no PIL can be entertained. Leaving it open to the petitioners to seek other appropriate remedies, the petitioners discussed.
This admission item number 2.
Yes, madam. And that the petitioners are the villagers of Badkul village under Mahakalapara Tahsil in the district of Kendrapada. The petitioner earlier filed another case bearing WBC PL number
Illegal encroachers
13,910 2020. My lord, the Honorable Court has passed an order under Annex 3. My lord, that order has been passed to ascertain the identity of the so-called encroachers and make a fresh representation to the authorities. As per the direction of the Honorable Court, I have made representations to the opposite parties.
When did he make, and where is the proof of having
Under
made?
Annex 4, my lord.
Where is the proof, sir?
He has sent me. Page 59 is the representation, and page 85 is the postal list.
All right.
Postal
The
list
petitioner's representation
in
bracket
spite of
annexure
7
4
months,
shall be examined by
in spite of lapse of 7
one minute,
months.
sir, one
they have
minute.
not-
The petitioner's representation bracket annexure 4 shall be examined by the Tahsildar.
By the Tahsildar Kendrapada.
No, Mahakalpada.
Mahakalpada.
District Kendrapada. And after issuing notice to the petitioners as well as opposite parties numbers.
So total 362 private opposite parties are there.
662.
362.
So this hearing will go on for the next 2 years. Anyway, that's up to you.
All they have
Opposite parties 6 to
encroached
662.
all the lands.
And after giving them a hearing, a reasoned order should be passed not later than 1st November 2022. The said order shall be made available by publishing it on a website.
Yes.
Soon thereafter. The court clarifies it has not expressed any view in the matter.
Well, the date has been fixed, man.
November to the Saturday.
Weekly list test admission item number 3.
So you're a designated senior advocate, sir?
No,
I see. Is it okay? You're wearing a certain kind of gown?
sorry. Well,
That's all. So it's a simple word, sir. I admire you.
yes, sir.
Ah.
Sorry.
We are wasting a lot of time trying to designate senior advocates. You make the exercise so simple.
Yes, sir.
Maybe we should wind up all that exercise.
Yes,
He's saying yes to that.
No, sorry, sorry, man. Sorry, man.
All right. Yes.
Item number 3.
Item 3 on behalf of Mr. Barik Miller, kindly taken up next week, man.
No adjournment like this, sir. What is it for? What is it for?
On behalf of Mr. Barik. He has he is on his legs. Another court.
Passover.
Yes.
Weekly list item number 4.
Plus 4 here, Malad, this matter relates to the recruitment to the post of junior typist in the office of the district judge Jajpur, Malad. This is a case where Malad, the candidate applied under the unreserved category and he successfully passed the written examination, and thereafter he was called for skill test. In the skill test and Viva voice also he was successfully passed. He has successfully passed, and the opposite parties have issued the have published the common merit list at page 25. If my lords may kindly refer to, there he has secured second rank, my lords. And my lords, thereafter, since no intimation was given to the petitioner, he inquired in the office and he got to know that serial number 1 who applied under the UR women category, she has been, my lords, selected and observed under the UR category, my lords. And subsequently, my lords, the
women is
candidate
horizontal
under the-
reservation, sir. Women is not vertical, women is horizontal reservation.
My lords, horizontal, but subject to the candidate having applied more than one category, my lords. The advertisement also specifically written, my lords. That at page, my lords. 20, if my lords may kindly refer to, they have specifically stated that the candidates desirous of applying for more than one category of posts are required to submit separate applications with relevant documents. But in the common merit list published, there in respect of the candidate at serial number 1, it has been specified under UR women category, but she has been observed under the UR category, for which there is only one vacant post available. That is action is prejudicing the right of the petitioner.
It will prejudice somebody, sir. Once you have a horizontal reservation, it's bound to prejudice the others in that category.
She topped in the merit list.
No, topped,
She
but
topped in the merit
she
list.
topped in the merit list.
She topped that is no, there is no dispute.
She
But
has been
she
treated as a general category candidate.
But she must have applied in more than one category, my lord. She had
Anyway,
applied,
you will
my
not
lords,
get it, sir.
Women category, my lords.
Even if you take out the women category, she still gets it.
She will she will get under the
anyway
women
get it,
category.
sir, whether it's women category or not, as unreserved, she gets it. There's only one vacancy.
One vacancy. is
So
there,
she'll
my
anyway get it. She's top of the merit list.
lords. If the opposite party would have observed under the women category as she had applied, then the petitioner would have got the opportunity to get.
No, if there are more than one vacancy, what is right? Say is right. There's only one vacancy, so nothing, no difference.
One vacancy under UR only, my lords. And
That's
one
right. So
vacancy
it
under
won't make a
UR.
difference, sir. You are also unreserved. She's unreserved. She's topping the list, so she gets it anyway. With there being only one vacancy for unreserved category, bracket UR bracket, and with opposite party number, what's her? She's opposite party. 4 having topped the merit list.
3, my lords. 3 has topped.
3, okay. Opposite party 3 having topped the merit list for the UR category. Come on, she would have anyway secured the position, even if it had not been reserved, horizontally, for women. That view of the matter. No interference is called for. The petition is dismissed. All right.
Weekly list for orders, item number 5.
Yes, my lord. My lord, item number 5 and item number 7.
All right. Memo is taken on record. The appeal is disposed of is withdrawn in terms thereof. Right.
My appearance will be taken into record.
All right. All right.
Item number 5 and 7. Both.
Right, sir. Right.
Weekly list item number 6. Item 6.
My lords, the petitioner and villagers, including Sarpanch of the Gram Panchayat, my lords, file a representation before the opposite party number 2 on 29th, 2021, my lords.
So what is the proof of this representation having been made?
Annexure 1, my lords.
What is the proof?
By postal receipt.
Where is it? Where is it?
I will file, my lords.
Huh?
Postal receipt also filed, my lords.
You have it?
My lords, I already filed, my lords.
Where?
Postal receipt.
Where is it filed? Postal receipt is not there, sir. Oh, it's there. I don't know. I'm not able to see it. This one. All right. The petitioner's representation dated 29th September 2021, bracket Annexure 1, will be examined by the
Tahsildar,
Puintala Tehsil.
My lord, he has not named the encroachers, so at least the.
Oh, in the representation also he is not named.
No, he has not named.
You have to name the encroachers, sir.
So at least his representation he may be allowed.
Yeah,
to-
you say counsel for the petitioner seeks leave to withdraw this present petition with liberty to make a
My
fresh
lords,
representation.
my lords, on the other hand, my lords.
Naming the encroachers and after
Pardon
following
me,
up
my
on
lords.
such representation to seek appropriate remedies in accordance.
Pardon me, my lords. On the other hand, the villagers are also given a representation before the collector, my lords. Grievance cell, my lords.
Sir, have you named the encroachers? You have to give names of the encroachers.
Weekly list item number 8.
Item number 8, my lord. Item number 8, ma'am, if my lord please the lordship, on behalf of Mr. KP Mishra, he's laying in another court, my lord. It may be taken up any week after a week.
No, no. So many defects.
That is
defects
also-
we removed, list after removal of defects. Defects we removed within a week, list after.
Weekly list item number 9.
Much of
Maybe legal lordship. My lord, in this case, the issue involved is settled by your lordship, my lord. In this case, my lord, the petition is challenging the audit assessment based on the audit visit report, which has been submitted beyond 7 days, my lord.
Covered?
Covered, my lord.
I thought something was before the full bench.
No, my lord, the facts is otherwise. My lord, may kindly turn to page 14.
Yes.
The bottom, my lord, audit profile.
Yes.
Completion of verification is 6/12/2008.
Right.
Submission of AVR is 11/12. So it is within 7 days. And my lord, he has taken that plea in the assessment proceeding. My lord would find the objection. My lord, may kindly turn to page 21, annexure 2, that is the assessment order.
So anyway, he can file appeal.
My lord, I'll just point out, my lord. My learned friend has conveniently bypassed this point, my lord. The lordship may kindly see page 14 top.
Yes.
There is a round seal, my lord.
Yeah.
And that seal is dated 19th December 2008.
Right.
And it is the acknowledgement of submission by the assessing officer. So therefore, my lord, if this date is taken to be the submission date, then it is.
We don't know about that, sir. We don't know if that seal is that.
My lord?
We don't know if that seal is the date on which the audit visit report was given.
The audit visit report has been signed on 11/12, but the same has been submitted before in the office of the assessing officer on 19 December 2008. That is the seal, official seal of the assessing officer, which acknowledges receipt of the audit visit report on 19 December.
What is the meaning of that handwritten thing at the bottom there?
My lord?
You come to the bottom of the page.
My lord, this
submission of AVR.
Submission of AVR is 11/12. But fact remains, my lord, this assessing officer has received this AVR on 19th December.
Which is right, then something is not right, right? Something is not right. Let it be tested in appeal. So in appeal, you can.
And my lord, this point has been taken before the assessing authority, and assessing authority has answered it at page 26. My lord, may kindly see.
Right.
26.
Just to cover up the delay, my lord.
No, my lord.
Whatever. Let it be challenged appeal.
I have taken this. I have filed a written submission before the assessing officer at the time of assessment.
You file an appeal, sir. If the counsel, the petitioner seeks leave to withdraw this petition with liberty to file an appeal and raise all the points urged in the present petition before the appellate authority in accordance with law. If such appeal is filed not later than 1st June 2022, accompanied by an application for condonation of delay, such application will be considered on its merits by the appellate authority in accordance with law, taking into account the fact of pendency of the present petition. The court clarifies it is not expressed any view on the merits. Is there any interim order here?
Yes, my lord.
The interim order passed with this court on 10th June 2010 will continue till such time the appellate authority passes an appropriate interim order on the application to be filed by the petitioner, provided it is filed along with the appeal within the date stipulated. You want the original, this is the original assessment order.
My lord.
The original of annexure 2 be returned to the petitioner, subject to substitution by an attested photocopy thereof. The petition is disposed of.
List item number 10. Item number 10.
My lord, I'm appearing from VC on behalf of the petitioner, my lord.
Yes.
Yes, my lord. My lord, your lordships may kindly have the last order, my lord, wherein the lordships are directed the state to file the counter affidavit, my lord. My lord, a copy has not been served, although the...
My lord, your lordship has directed me to file the counter affidavit on last date, my lord. But last date, because after all, I found that the counter was already filed in the year 2012, my lord. Since I had not the copy of the counter, I had brought it from the e-copy of that entire case record, my lord. So I'll give a copy because I was hoping that you will be here today.
Or a copy of the counter will be served on counsel to petitioner within the next 3 days. Rejoinder of the next day. 12th July.
Grateful, Your Lordship.
List item 11. Item number 11.
My lord, in this case, your lordship has directed me to find to file the status report. I have received the status report, but I'm extremely sorry. There is no copy, only one copy. But I'm just reading. I'll take only 1 minute. The final status report is that I'm sending it to your lordship. After completion of investigation, the sanctioning authority have been moved as follows to accord sanction of prosecution against the government office. There are 5 government officials who are found to be guilty of committing offence, and we have asked for sanction on section 197 CRPC, and that is pending. This is the status.
When did you ask for sanction, sir? The date of seeking sanction?
That date is not there, but this is the current status.
No, but this is a 2013 matter.
5 officers.
ES case is registered in 2015 only. But at least for 7 years, no sanction has been got then. Mr. Monty hands over the communication dated 15 February 2022 from the SP Vigilance Sambalpur, stating that after the intervention of the court, ES case number 48 dated 20th May 2015 has been registered at Sambalpur Vigilance PS. However, the report is not clear on whether sanction has been granted for proceeding with the criminal case against the officers concerned. An affidavit in this regard we filed. Within 4 weeks, updating the current status. This on 5th July.
Weekly list item number 12. May it please your lordships. Lordship may kindly turn to page 40, annexure 3. An assessment under section 143(3) was completed on 31st of December 2010, and a sum of and a demand of rupees 29 lakhs was raised by sustaining the addition on sundry creditor. Thereafter, my lords, I went to first appeal. First appeal deleted that amount that I mentioned in page 5, and department went to the second appeal. They lost it. Then, my lords, lordship will kindly see this assessment was reopened under annexure 4, page 45. Lordship may kindly see page 45. The notice, the reason they have provided.
So this assessment order in 147 is appealable.
No. At 147 order, this order was challenged in the revision because 264, because the time limit for filing the appeal was
crossed.
Yes, crossed.
Where is that revisional order?
Malice, revenues order. For a minute, I will just take your lordships to
25/3/2015.
Annexure 4, page 45.
Yes.
Lordship have seen?
Yes.
Then, my lords, this is the reason from the details it is revealed that the assessee has provided. There is no tangible material for reopening. Then I file an objection time and again. 5, 6, and 7 are my objections. Sorry, 5 is my objection, then 6 is their reply. Then again, I file another objection, that is at page 49. I'm just placing the bottom portion of annexure 7, what they have written. In view of the above, it is submitted that the assessee had enough of own funds to make the advances in question, and there being no nexus between the borrowed funds and advances, no part of interest paid by the assessee to banks, financial institution is disallowable. The assessee relies on the decisions quoted by him in his earlier submission, hopes that the proposed disallowance shall be accordingly dropped and for which the assessee shall be grateful. Now, without disposing of this objection, the next page your lordship will find Annexure 8, page 50, para 2, I am just bringing to your lordship's kind notice. Thereafter, lordship will kindly see, from the assessment records, it is revealed that he has provided temporary advance of rupees 7.96 crore in respect of 9 concerns. So, the assessing officer, without having any new material or tangible material, and without disposing of my objection, straight away went and completed the assessment by raising a huge demand of rupees 95 lakhs some
So is this not appealable? That's the only question.
Yes, that is not appealable. I went to the...
you went straight in 264.
Yes, 264.
Yes.
And the learned commissioner, my lords, he has not touched that point so far as change of opinion is concerned. He has discussed it on merit and sustained the order of
What was the material on the basis of which the reopening happened?
Reopening is happening, my lords. There is no material for reopening. There is no material for reopening.
Lords, we have just seen. After 4 years?
Yes.
Yes, Mr. Chimanka.
And I am giving the judgment. Lordship have held in Bire Simani's case, reported in 436 ITR of this Honorable Court, in also in the case of Tough Tubes, where your Lordship have held that if it is based on accounts, nothing can be reopened. Lordship have categorically held. I am giving the judgments, my lords. Sorry for the delay. I am giving the judgment. That is own lordship. My Lord Chief Justice, sitting is Justice Patnaik. Tough Tubes, very recent judgment, my lords.
And
in the month of February, lordship have delivered. The second page, your lordship will find that it is based on accounts. So therefore, no tangible material.
Yes, Mr. Chimanka.
My lord, page 16 of the Commissioner Order. Reference is made to the ruling given by the Honorable High Court of Punjab and Haryana in the case of Commissioner of Income Tax versus Munjal Sales Corporation in 298 ITR 294, and in the case of Commissioner of Income Tax versus Abhishek Industries, in which the Honorable Court held that the SSC will not be entitled to claim deduction of the interest on the borrowing to the extent those are diverted to cistern consent and other consent without interest.
The reasons for reopening. Come to the reasons for reopening.
Reason 45. Page
16.
Page 45.
Reasons for reopening, sir.
Page 45 of the brief.
Page 45.
Yes.
From the details, it is revealed that the SSC...
What is this details? What is this details? What is the material?
Is diversion of money of rupees 7.96.
What is the details, sir? What is the material on the basis of which you're forming this opinion? What is that material?
Annexure 8, my lord, from there, lordship, I'll again pray your lordship to turn to Annexure 8, the order of assessment. Therefore, from the assessment records, it was there earlier. It was there earlier. It is revealed.
Correct. No new material, sir.
No new material.
All right, we pass the detailed order.
Oblate.
Writ petition is allowed. The impugn order set aside. And the order of reassessment is also hereby set aside. And all constitutional orders.
Annexure 1 to be quashed, man.
Right.
List item 13.
My lord, I am appearing from video conference.
Yes.
My lord, we have received a counter from the state on 25/4/2022. Kindly seek time to assess this counter and file a reply.
All right.
We have filed our counter.
All right. Rejoinder filed.
We have filed a rejoinder before, but the state has complied with the counter after a long time, so we will file a reply to this.
Right. Reply to the states. Rejoinder to the states counter be filed for the next one. Just on 18 July.
Weekly list item 14.
May I please, my lord, item 13, counter copies filed by the state may be given to me. I am the opposite party 5 to 9, my lord.
All right.
Item 13, my lord.
13. Okay. Let's put down his name.
13.
13.
Item 14.
May it please this honorable court. I am appearing for the petitioners in the matter.
But in this
Kindly
matter,
take a-
lordships were pleased to pass an interim order on 24th of January, which they have complied with. And I have received the Paravej's comments on 29th of March. I need some time to file the counter affidavit. Your lordship may read up after the holiday so that I can file the counter affidavit.
Mr. Samantra.
I'll pray for continuance of the interim order.
All right. Mr. Samantra appearing for?
Yes, I am appealing for the state laws.
Seeks and is granted 8 weeks time to file reply. Adjourned up to the next date. Interim order to continue. Based on 2nd August.
Complaints.
Weekly list item 15.
2nd August.
Wait, please, my lords.
15 in the month of
Lords,
February,
this
my lord,
matter,
issued
your
notice and directed us to file the counter affidavit. I have not received the Paravej's comments. I pray for some more time to
Mr.
file.
Modi seeks and is granted last opportunity to file reply within 8 weeks. Adjourned up to the
only thing, my lords, I just wish to point out, your lordship will have the IA at flag B.
Yes.
That's the modification application your lordships had directed. If your lordship will have that IA, the para 3. Para 3, your lordships had actually dictated, my lords, where I'll just read out. It will be open to the petitioner to bring to the notice of the court in individual instances where any self-trained, unqualified person is being issued registration certificate. Well, that's the only thing that I wish to point out, Mulats, is that this observation has is not there in the earlier order. So that observation may be recorded.
OP number 3, Union of India, let the survey copy of the same.
What is the new application?
It's a new application only for rectification. What your lordships dictated, that has not actually perhaps inadvertently skipped out from being typed in.
For the reason stated, the application is allowed. The following sentence be added to the order dated 10th February 2022, open quotation, to be open to the petitioner to bring to the notice of the court individual instances where any self-trained, unqualified person is being issued a registration certificate, unquote. The application is disposed of.
Lordship is having this matter.
Yeah, you say pleadings, the reply we filed within. Who's appearing, sir?
I am appearing.
The state is appearing for 1 and 2 and where for OP number 3, my lord.
All right. Last option is granted these opposite parties to file their replies within 8 weeks. Rejoinder for the next one. 9th August, not sorry, 10th August.
10th August. Very well.
Weekly list item 16.
My lord, last occasion, your lordship directed the opposite party to obtain instruction in this matter, my lord.
Yes.
18.
16.
What are the instructions?
Yes, my lord. 16.
Some more time.
Just a minute. File is not.
Mr. Monty states that he needs more time for instructions.
Time may be granted.
Add his request list on. What's the urgency, sir?
My lord.
What is the urgency?
My lord, they are.
Yes, I got it. My lord, I need some time to file counter.
All right.
My lord, urgency, my lord, they are implementing projects, my lord. Without earlier this honorable court directed not to implement that. My lord, thereafter they implement and dispose of this matter. Thereafter this petitioner came for.
Sir, you are the Society for Prevention of Cruelty of Animals. Are you appearing that matter?
Yes, I am for the petitioner, my lord.
So what has to do with project, sir? This is about cruelty to animals.
Yes, my lord.
You say yes to everything. What has it to do with projects?
My lord, they inserted veterinarian. My lord, illegally, my lord. This proceeding was issued illegally. That is the matter, my lord.
May I permitted, my lord?
No, 1 minute. These opposite parties
are the members, all are the members, my lord, board members. And my lord, what happened, my lord? Annexure 3, my lord. They serve notice to only 11 person. My lord, board member are 20. Your lordship kindly take a glance to Annexure 3.
The counter will be filed within 8 weeks, joined up to the next week. Just on 11th August.
Weekly list item 18.
The question has been framed at page number 4, madam. Whether in the fact and circumstance of the case and in law, the land and ITT Cuttack is justified in setting an order passed under section 263 of the IT Act, passed by the Principal Commissioner of Income Tax, Cuttack Charge Cuttack, whereas the Principal Commissioner of Income Tax, Cuttack was within the revisionary jurisdiction, invoked provision of section 263 of the IT Act, considering the assessment order erroneous insofar as it is prejudicial to the interest of revenue, since the assessing officer has accepted the claim of the assessee vis-a-vis loan creditors without causing any verification inquiry. Next, the page 3, that it is submitted that in the case of Ram Pyari Devi Saravagi, 67 ITR, and Srimati Taradevi Agarwal versus CIT, the Honorable Supreme Court of India has held that lack of inquiry and verification of relevant time by the assessing officer would constitute prejudice to the interest of revenue and involve error of facts and law, thus triggering provision of section 263 of the IT Act. Similar in the case of Denial Merchants Private Limited and others versus ITO in SLP number 23976 of 2017, the Honorable Supreme Court of India, as per order dated 29/11/17, upheld that view of the order passed under section 263 of the IT Act was correct and in satisfying the order, assessment order and directing the assessment order for causing detailed inquiry. My lord, the assessment order, the tribunal order, page 6. The brief fact of the case are that the principal CIT Cuttack observed that the assessee, Mr. Sonali Jonas, has claimed to have received loan rupees 1,82 lakhs from the loan creditor, Mrs. Pyramid Supplier Private Limited during the previous year, limited assessment at 12/13. He also noticed that the assessee has claimed to have received loan of 2,62 lakhs from the same loan creditors for the assessment year 2013-14 in the assessment of 14-15 from the same creditor, which was accepted without causing necessary inquiry, verification in regards to genuineness of transaction and creditworthiness of the loan creditor. He further observed that on examination of the case record of the assessment year,
notice returnable. Mr. Panda, you appearing? Watch it.
Notice have already been read complaints, and they
will frame the questions.
The notice have been read that we are raising objection only before the lordship. That is the order passed by the Principal Commissioner, page 18. After verification of the details, kindly have a glance to, that is Annexure 3, page 18, my lord, that the loan commissioner himself has read. They mentioned the AO has only obtained confirmation letters, audited accounts for the assessment of 2012-13, and the loan of the creditors of the assessee has not caused any inquiry.
And
then from the records, it is observed that no due inquiry is made. But now, when the reply of the assessee was read, the same page, the fact of a loan transaction with the pyramid suppliers, private limited, or specifically and thoroughly examined by the loan AO during the assessment proceedings, the assessor has furnished confirmatory letters along with the respective audit report and the copies of bank accounts through which the transaction made, and those are kept in the record by the loan AO. Thus, this can be verified from the assessment records both the years. When all these things have already kept in the record, so, but by saying it is erroneous or prejudicial without conducting or verifying the record, and Joint said it could have verified everything from that place. But what better inquiry could have been made? That he himself said in the next page, after careful consideration the issues from the assessment records, Also, the submission of the AR of the assessee, I am of the view, AO has failed to examine. What examination could have been made better than the audit report, better than the confirmation letter, better than that? Then who prevented the Lawrence CIT to confront all these things? But because only it is erroneous or prejudicial without application of mind. And the similar occasion, my lord, page 21, the preceding year loan, whatever has been kept that pyramid, that has already been accepted by the tribunal. The same transaction. That has been also raised page 21 in view of the above. The assessment order in question is hereby set aside and the AO has adjudication of the issues afresh to reframe the assessment order after proper application of the facts, application of the law. However, the AO may examine the implication coming out of the decision of the Gurmantra set to be pending before the ITAT. Needless to say that this repayment, this has been accepted. So once the tribunal accepted preceding year, yes, ma'am. So what necessary could have been made without application, non-application mind, no, nothing has been done, nothing has been done.
This order has not been challenged.
Yes.
This order has not been challenged.
Yes.
The order is enclosed.
No, this one you have not. This previous year. That which you have pointed out in your to commission pointed out as page 21. That order is not there. That order is the tribunal accepted.
No, 1 minute. This Gunwant Rai said,
yes,
Babulal and company, how is it related to Sonali Jewellers?
No, this assessment order which is
Sonali. Assessment
order that is clearly the address is care of Babulal and Co. and the proprietor of Sonali.
But there, the Gunwant Rai said it is proprietor Babulal.
13 assessment order.
12:30. Preceding occasion. What the Lawrence CIT himself had said. And who prevented? Conduct inquiry and going to the deep. And what better you could have been made?
Proprietor is same. All right. You see, the revenue is in appeal against an order dated 19th September 2017 of the Income Tax Appellate Tribunal in ITA number 162/CTK/2017 for the assessment year 2013-14 bracket AY 2000. The question sought to be urged is whether the ITAT erred in setting aside the order passed on 23rd March 2017 by the Principal Commission of Income Tax bracket PRCIT under section 263 of the Income Tax Act 1961 bracket IT Act. Setting aside an assessment order and requiring the assessing officer bracket AO to adjudicate the issues afresh. Paragraph, it is seen that the order of the principal CIT in the operative portion, read as under, take page 21, the penultimate paragraph of the order in view of the above till to the SSC, the whole paragraph. Consent for the SSC points out that the decision referred to here in the above paragraph, namely of the ITAT, dated 6th August 2000, was of the ITAT and it was dated 6th August 2018 in ITA number 517/CTK/2017 for the AY 2012-13, involving the same entity, that is Shri Gunwant Rai Seth, proprietor of Messrs. Babulal and Company. Incidentally, he is the same proprietor of the present petitioner, that is Messrs. Sonali Jewellers. Paragraph of perusal of the said order dated 6th August 2018 of the ITAT reveals that it has decided the issues raised in the present appeal as well in favor of the SSC and against the revenue. The said order dated 6th August 2018 of the ITAT has attained finality since the revenue is not further challenged. In that view of the matter, no substantial question of law arises in the present appeal. It is dismissed as such.
Quickly, item 19.
19, 20, 21.
Yes, sir.
Yes,
the
sir.
question is the interest which are taxed by the IO before the pre-operative of the company, and the interest was received from the FD, which was converted from the mutual funds, and
so whether it's capital receipt or revenue, capital,
whether it's either capital or revenue, Lordship was held Bucharest, considering the Bucharest Steel and Putty Canning, Lordship was already rated against the revenue.
Right. So say in view of the decision,
that may consider the Lordship kindly have examined that is cover, I think. Nilachal Ispat Nigam Lordship also.
Correct.
And therefore, next question is not relevant because first question not correct, and then next question.
In view of the decision of this court dated 17/11/2021 in ITA 8 of 2005 bracket Messrs. Nilachal Ispat Nigam Limited versus Assistant Commissioner of Income Tax, no substantial question of law as urged by the revenue arises in these petitions, these appeals. The appeals are accordingly.
3 years in.
Right. Same order.
19, 20, and 21.
Correct.
Quick list item 22. Item number 22.
Mr. Katkia?
Yes, Master, I am happy.
What's the position here? The appellant?
Yes, Master, he is surviving. He is surviving and residing in his village. Sarigidi, his village name is Sarigidi, along with his family.
None is appearing for him, Mr. Katkia. Okay. Mr. Katkia informs the court that the appellant who was enlarged on bail by the order dated
Yes, in 2010 he has released bond.
January 2010 is very much alive. However, none appears. You are appearing.
And in this case, petitioner is in custody since 2001, my lord.
No, he's on bail.
My lord, there is no eyewitness.
He's on bail right now.
My lord?
The appellant is on bail.
No, man, no, man.
Yes. 6 January 2010, he was granted bail. Oh, for interim bail, is it?
My lord, give me some time, I will inquire the matter.
No, it has already been inquired into, and the IAS has Govindpur.
Yeah, he's on bail since 6 January 2010. He's on bail. Anyway, you argue the appeal. Yes.
My lord, at the time of incident, he is 25 years old, my lord. My lord, he wrote the letter on 2004 that he is in custody. But I do not know he is in bail or not.
We can tell you, madam, there is an order granting him bail. You show her the order, please. It makes no difference. You argue the appeal anyway. Here, please show her the order. You are not able to believe us when we tell you.
Give me some time, I will file written argument.
All right, orders reserved. You also file written arguments. PW1?
PW1 is the eyewitness.
All right. Written arguments will be filed within a week. Orders reserved. All right.
Weekly list item 23.
None appears. This is not.
Please,
You are there.
all these writ petitions matters raise a substantial question of law, my lord. Whether, in view of the constitutional provision Article 243Q, my lord, the municipality can impose holding tax on industrial towns, industrial estates matters. That is the sole questions involved in all these writ petitions matters. So Article 243Q, my lords, provides says that if by notification, state government has notified its industrial estate or townships, the municipality has no jurisdictions on that territory matters. So there is no territorial jurisdiction.
May I just one technical point, my lord. And in other writ petition, the batch of writ petition filed subsequent to the petition filed in 2009. In 2017, my lord, in the midst of pending, that in 2015, government has resolved one resolution on 13/11/2015, which is under challenge in subsequent writ petitions, my lord. And in view of the challenge made to the government resolution, government has not filed any counter. Government is to defend its own resolution.
Who are you for, sir?
Case has totally.
Whom are you appearing for?
I am appearing for the municipality, my lord.
Municipality.
They are challenging the authority of the municipality.
Yes. Who's for the government? Mr. Mudli.
I am appealing for the government.
So Katke, you are appearing?
Yes, I am.
Yes.
But government has nothing to do in this matter because it's purely dispute between municipality and all others.
No, he says in 2017, the challenge in the writ petitions of 2017 is to the
Resolution
government
dated
resolution.
13/11.
Government resolution dated 13/11/2015.
They want that it should be quashed, my lord, totally quashed.
It is seen that the challenge in the writ petitions filed in 2017 is to the levy of holding tax by virtue of a resolution dated 13/11/2015 of the government of Orissa. Therefore, it is incumbent on the government of Orissa to file a reply to the petitions filed in 2017. Last opportunity of 8 weeks is granted. The government to do so. Rejoinder before the next day. 23rd August.
Weekly list item 24.
Interim order, all these cases may be, my lords, continue.
All right, interim order.
Much obliged.
Item 24.
May I please your lordships? In the given case, my lord, may I please your lordships?
Yes.
In the given case, my lord, the impugn notification by the government of Odisha in the Information and the Public Relations Department is under challenge, my lord. Whereby and whereunder the government passed the notification keeping the General Administration Vigilance Department out of the purview of the Right to Information Act. Your lordship may kindly turn to page number 16 of the brief, whereby I have submitted that, respectfully I submitted that in the case of state of UP versus Raj Narayan, my lord, and so also in plethora of judgments, my lord, the fundamental right to access to information is recognized as part of the basic structure doctrine, my lord. Therefore, my lord, the impugn notification also strikes at the root of right to preamble, Right to Information Act 2005 and the rules made thereunder. You'll also may kindly next turn to page number 9, my lord. Page number 9 of the brief, my lord. Section 24 of the Right to Information Act 2005 is reproduced for the kind convenience of your lordships. I respectfully urge your lordships to turn to page number 9, my lord.
Sir, if I remember right, Section 8 makes an exception only on limited grounds.
My lord, the Vigilance Department cannot be ousted from the purview of the Right to Information Act, my lord, because the preamble says that information pertaining to the allegations of corruption and human right violations shall not be excluded under this subsection, my lord. Section 24, your lordship may kindly, I urge your lordship to say, read section 24. That is also reproduced in the brief of your lordships at page number 9.
So you can't have an entire department excluded.
My lord, that is the sole submission, my lord. There may have reasonable restrictions, but in total, they cannot oust the business department.
Correct.
Lord, I have filed a written note of submission. Is it that in the record? Lordship.
Yes, it's there.
Lordship may kindly come to the first page, Lord. So, in fact, I have just made a comparative chart where the central government has excluded 26 organizations. No. Your Lordship, just I'll address that issue also, Lord. And the organization which were included in that 26 numbers, 26 numbers, there is in the serial number 1, there is Intelligence Bureau. Serial number 3 is Directorate of Revenue Intelligence. Serial number 4 is Central Economic Intelligence Bureau. Serial number 5 is Directorate of Enforcement.
No. So what, sir? When that is challenged, we'll examine that. What is the parallel you're drawing?
So, my lord,
whenever that is challenged, we'll examine that, whether it's justified to exclude it.
No, my lord. Section 24, there is a distinction between section 8 and section 24. The word public interest is not there in section 24, my lord.
All right. So, what part of section 24 you want to rely on? Let's come to that. What part of section 24 you want to rely on?
Lord, right to
24 applies only to central government.
No.
Sir, 24 applies only to central government.
The main clause is different section.
So subsection 4 applies, 24(4) applies to state government.
Yes, my lord.
That is with regard to intelligence and security organizations, my lord, not for vigilance.
Not Department of Vigilance. 24(4), come to 24(4).
And in 24, the provided clause is very clear, your lordship.
That's what?
My lord. Notwithstanding contending in this act shall apply to such intelligence and security organization, being organizations established by the state government, as that government may from time to time, by notification in the official gazette, specify.
This is neither intelligence nor security, sir. This Department of Vigilance is neither an intelligence department nor a security department. Security organization.
No, my lord, I'll address it, my lord. My lord, just now I got the file, so I have not prepared, my lord. So but my lord, this exact notification on other states, my lord, was also challenged in Madras, in Himachal, and another 3 states, my lord. And all these cases, they have somehow, my lord, I have enclosed the judgments. But your lordship kindly grant me one more time.
Lordship further appreciate the 7-judge bench of this of the Supreme Court of the Honorable Supreme Court in SP Gupta case, my lord. Your lordship kindly turn to page number 17, where the Honorable Apex Court has categorically said that there is also in every democracy a certain amount of a public suspicion and a distrust of government, varying of course from time to time according to its performance, which prompts the people to insist upon a maximum exposure of its functioning.
Sir, an entire one minute, sir. An entire department being exempted makes no sense, sir.
No, my lord, it is applicable. Your lordship may kindly see clause 5 or paragraph 5 of my written note. I have said there is in chapter 6 of that handbook, Vigilance Police Instructional Handbook, my lord. Part 4, 2009, under chapter 6 deals with organization, control and supervision, and chapter 16 deals with miscellaneous provision. Stipulates that the appointment of PIO and appellate authority in terms of the RTI Act. There, my lord. Hence, any information which is permissible to be furnished can be granted under RTI as per the Vigilance Manual. I have also enclosed that copy, my
lord. Which date is that?
Paragraph 5.
No, which date? What you're reading, is it part of a notification or a reply?
No,
No,
my lord,
handbook cannot override the statute.
written note, my lord, written note.
Sir, page 22 is the notification.
My lord.
Page 22
Yes,
is the impure notification. You have not withdrawn this notification, sir, so it's very much there. And it's too broad. Nothing contained in the Act shall apply to General Administration Vigilance Department.
In its entirety, the government have formulated has passed notification.
Let him answer, sir. Page 22.
Yes, ma'am. The state government has special nothing contained the state that shall apply to GA department and yes, they have excluded.
Yes. Entire GA department is excluded, sir.
Lots of kindly come last chance, my lord. I have
no, you file your written note of arguments. Orders reserved.
Lord, Vigilance Council is supposed to also.
Parties are permitted to file further notes of arguments within 2 weeks, within 1 week.
We are deeply obliged. All the three petitions are on similar grounds.
Similar grounds. All right.
Deeply obliged.
My lord, the Standing Council of Vigilance Department, he wants to.
My lord, in this case, I have filed 2 cases, my lordship. I have received the notice. And in 2 cases, my lordship, I have filed intervenor petition. And that is pending, my lords. That has not
Intervention
been
was already allowed. That was already allowed by the coordinate bench of this honorable.
Already allowed. If you have anything to say, you put it down in a note, sir, within a week.
Deeply obliged.
Weekly list item 25.
Item number 25. It is a lengthy matter. It cannot because that already.
My lord, I am the petitioner Jagannath Bastia. I conducted the case in person. My lord, the Honorable High Court has directed the opposite parties to file their reply in response to my amendment in this case number 11968 of 20. The order 10, my lord. But the opposite parties have not yet filed their reply in response to my amendment petition. Moreover, my lord, in the order number 11, the Honorable High Court has also directed the opposite parties to file their written statement and a reply in response to my interim application number 7092 of 21. My lord, they have also not yet filed their reply. Therefore, my lord, I pray, my lord, kindly allow my amendment miscase number 11968 by 20. Rather my interim application 7092/21 may kindly be allowed and the status quo over the land of Bagala Dharamsala.
You not filed replies to these IAs?
Yes, we'll file.
You filed?
No, we have not filed. We'll file the IA for amendment. Amendment.
You have not yet filed.
IA for IA 11968 of 2020 for amendment. Mr. Bonti states that he will file a reply within 2 weeks, rejoined with the next week.
The land of my interim application kindly be allowed and stay on further transfer of the land of Bagala Dharamsala.
That matter has already been raised before a lordship. Your lordship has said no. And in the main writ petition also, they have asked for stay and injunction that was refused.
No, your lordship is to hear the main application. I am appearing for the Jagannath temple in the other matter, administration. So you will hear the matter any day.
My lord, while the matter is subject before the Honorable High Court, the collector will once again trying to transfer the remaining portion of the land of the Bagala Dharamsala. In absence of any interim order from the Honorable High Court, my lord, the collector will once again trying and issue a notification for transfer of remaining portion of the Bagala Dharamsala. Therefore, I once again pray, my lord, kindly allow my interim application number 7092 of 21 and grant status quo and stay on further transfer of the land of Bagala Dharamsala till disposal of the case, my lord. It's an extremely urgency for the interest of the public at large.
We'll have it soon on the opening, sir. 22nd June.
22nd June.
Your Lordship, in the first three petitions, interim order to continue, my lord.
All right, interim order to continue the first.
Weekly list item number 3. Weekly list pastoral matter item 3.
May I, Lordship? The petitions are the villagers of Pradhanpalli in the district of Bargarh have challenged the inaction of the opposite parties, my lord. 1, 2, my lord. 4, my lord. Have not taken any action against the opposite point of 5 to 7, my lord. The opposite point of 5 to 7, my lord. They have removed the Chokonala and Chokorasta constructed by the government for irrigation of the land and for agriculture, my lord. They also annexed the map and so approach the authority that is annexer 10, my lord.
This has to be disposed of. What is the proof of service? All right. The petitioner's application.
My lord, the petitioner has already approached this honorable court, and the honorable single judge, while disposing the previous writ petition, has passed the following order.
Now he is
no, my lord. So in the event petitioner is interested for removal of encroacher, he may prefer demarcation proceeding before the Tahsildar Boharapalli with the subdivision representation disposed of. So he may be directed to approach the Tahsildar and initiate demarcation.
My lord, yes, I have already disclosed that order, my lord. Already demarcation proceeding is there, but after demarcation, they have already removed the demarcation pillar and totally removed the constructed canal and a road. And the Tahsildar also initiated an encroachment proceeding, that is annexure 9, my lord. But then not taking any action, my lord.
But how is it a PIL then? Why is it a PIL, sir?
But those persons those who have landed agricultural land in that area, my lord, they have approached before lodge, my lord. They could not able to agriculture to irrigate their land and to cultivate their land.
In fact, the petitioner was the petitioner in that case. Single judge is the petitioner.
A single judge petitioner 1 has approached you.
No, why have we made this a PIL?
But the entire village of the Pradhanpalli have been affected, my lord.
So what? Even in this order,
there is no canal for irrigation of the land, my lord. The government had constructed during the consultation proceeding for irrigation of the entire Chapka area and for movement of the people, my lord, to collect their issue facts, my lord.
Tahsildar may be directed to him.
All right. The petitioner's application, bracket next 10, shall be examined by the Tahsildar Barpalli, and after issuing notice to the petitioners as well as opposite parties 5 to 7, and after giving them a hearing, a reasoned order to be passed not later than 8th August 2022 and be communicated to the parties not later than 16th August 2022. The petition is disposed of. The court clarifies it is not expressed.